motion to revoke based on the charge. We had a trial date that's been taken off, so I think we need to do today is set a hearing date.
Okay, let's see. When are you planning, or when would you like me to do that, I guess?
Yes, whatever the revocation we have next week.
Yeah, it'd be next Tuesday.
I'll be okay with doing
Yeah, I mean, we do have about 45 hearings scheduled for next Tuesday because we didn't do any last Tuesday, so.
Well, since he's out of country, Judge, I don't care to do it. Is it going to be next revocation day 2 weeks after that?
Yeah, we'd have June the 8th.
I don't like that. The charges are that off taking that he's got to do DUI, but I would be okay with doing June 8th.
Okay, so Ms. Myers, I guess you're going to be doing this one, right?
I will, Your Honor.
Okay, thank you. So we'll go to June 8th. That'll be at 1:30
Judge,
in the afternoon.
Since we're waiting for June 8th, his new charge is DUI with possession of marijuana. I don't think it's ever a bond condition. Can we have drug testing as a condition of bond?
I don't have any idea what conditions, if any, he's got on there. Let me look. Because this underlying case that we're dealing with here wasn't a drug-related case, so I'm not sure he had any. Yeah, he didn't have any conditions like that. Okay, that's I guess I'll consider that a motion to add a condition to his bond based upon those new arrests. Do you want to talk about that? Do you want to be heard about that?
I think we would be agreeable to that new on revocation here.
It's not going to be a levy. He's out there getting 2 new charges. And, push the hearing date off. I think the safety of the public paramount in the situation. He's driving around smoking drugs, but he's not supposed to. He's out on line.
Has that already been resolved, that new charge?
I don't think so.
So it's still pending.
It's a new charge.
Without sitting here and researching that, I believe that while it's certainly not against the rules to add a condition to bond based upon if there has been a change in circumstances, I feel like my gut tells me that has to be, that there would be an inherent notice and opportunity to be heard aspect to that from a due process standpoint that we wouldn't have. I understand you filed your motion and it asked for his bond to be revoked, and frankly, I could probably take evidence and revoke his bond today if you put evidence on. But I think those are two different questions, and I mean, I feel like I should probably err on the side of caution, because of the due process angle that comes in to a pretrial release and any modification of those conditions. I do agree with Mr. Richardson that if you are out on bond and I'm not asking you to say anything, you got a lawyer, I don't want you to, but if you're out on bond and you get arrested on, especially when you have a case that's got a charge as serious as this case has, there's some things that cause us to be concerned. I think any reasonable person would be concerned when you are picking up new charges, and apparently there's been 2 different new charges. I don't know anything about how they've been resolved, if at all. I don't know where they are, if they're in the process of trials have been set or pleas have been entered. I don't know any of that. And that's what we'll have a hearing about and find out. But in the meantime, I want to tell you that, it's any additional problems that you might have between now and then will not help your case any, okay? Won't help your cause any. And, in theory, that could be something that I add after we have a hearing, or, you know, your bond could get revoked after we have a hearing. So you need to understand the gravity of it. Okay. That being said, again, I'm not asking you to say anything. So you stay in contact with your attorney. We'll set it on June the 8th, and we will see at 1:30, and we'll see how things turn out. Okay.
Thank you, Honor.
Amanda Warner. Oh, did you? Oh, okay. Is that you? If you'll come right up here to the blue line. I was just going down my list, so it just turned out.
Judge, Ms. Myers and I talked about this case a couple of weeks ago. This was one where initially she was charged with a co-defendant of both trafficking offenses. Since that time, I've kind of gotten a little bit more of a better story behind what happened. And a lot of what they had told me kind of matches up with a lot of what I was thinking as the case progressed. Although I certainly think the grand jury found it was probable cause that something had occurred. Our co-defendant did plead out in this case, and I don't believe, based on the evidence that I have, that I can obtain a conviction at trials. So I would ask the court to dismiss this case with prejudice.
Okay, I'm assuming you don't object to that.
We're not objecting. No.
Okay.
Go ahead.
That's what I was going to ask you, is if you all thought, if there was anything residual that needed to get cleaned up.
Well, I think there were some items that Ms. Warner had in that car. The story I was given is that she was in the process of moving, which kind of, the stuff that was found goes along with that. I don't know what items were left, but whatever items were being held by KSP that was in the vehicle, I think it was a football.
There's a signed football, as well as a tech. The big significant items. I think there were some other items too. Two main items she was concerned about.
I mean, I don't think anything needs to be, unless it's something obviously illegal, I don't think it needs to be held by KSP. These heirlooms, football, may or remain.
I guess I'm concerned that they might wonder about the provenance of me just handwriting something on this docket and you take it to KSP. They might be a little nervous about that. I don't mind doing that with the understanding that despite any kind of, you know, jurisdiction issues, that the case would be dismissed. I think you all could probably do an agreed order if this doesn't work. I don't mind writing it on the docket that anything that's being held in the evidence that doesn't constitute contraband can be returned to her.
And I did tell the officer he was agreeable with this case being dismissed. They're aware of it. But if there's a problem, I don't care to call down there myself.
Okay. Well, I mean, the quickest way to do it would be for me to write this on here. They'll probably enter it tomorrow. They could mail a copy to Miss Warner if she'll give an address, if y'all write it down or something. And then she can try to see if that works before we do anything else.
I think that's probably the best approach, Your Honor. If she has problems with that, then I'll send an agreed order to the Commonwealth.
Okay. All right. Do you want to write down her address so we can put it, if it may be the same that it's always been, I don't know. Yes. Yes, ma'am. It's fine. Thank you. All right, Miss Warner. So we'll we'll get this taken care of. Hopefully you'll get this order in the mail. It's going to look kind of sketchy because it's just handwritten, but you know, the state police has seen my writing before, so that'll probably be all right. Okay. All right. Thank you. All right. Mr. Galinsky, you ready?
Can you hear me?
I can hear you. Yes, sir. Are you ready? Are you ready to go?
Yeah.
All right. Mr. Berry, I guess this was done by, it was Miss Hill was who saw him down in district court, but I'm going to pop this up here where everybody can. All right, Mr. Galinsky, can you raise your right hand? You swear to tell me the truth, so help you God?
Yes, sir.
All right, thank you. I'm going to show you a document that has been handed to me. That document is called a motion to enter a guilty plea. Do you see that?
Yeah, I got copies of it here.
All right, and it's got a signature on it that, of course, is not your real signature. It's a virtual signature. Did you look over this document and authorize your attorney to place your virtual signature on it?
Yeah.
Okay.
I sent her copies of them where I signed it too. I faxed it to her.
You have a copy that you actually signed it?
Yeah, I faxed them to Miss Hill's office about a week ago.
Oh, okay. Can you hold that up to the camera and let me look at it?
I don't know where the camera's at. Can you see it?
Oh, yeah. I got you. Yeah, that's on the offer sheet from the Commonwealth, and that's what I was getting ready to ask you next. So,
I got two of them, 2 copies of it.
I got you. So, does your copy that you're looking at there, is it the same as this?
Yeah.
Okay. And the copy that I have, of course, just has a virtual signature again on the back. It doesn't have your actual signature, but you say that you've actually signed that, right?
Yeah. I got them right there.
All right.
Yeah.
Very good. And are you comfortable with the time that you've had to look over those things and to talk to your attorney about it?
Yes, sir.
Okay. Do you feel like you are being forced against your will by me or anyone else to plead guilty to anything?
No, sir.
You understand that you have the right not to incriminate yourself and or to say anything that could be used against you, but you waive that if you plead guilty.
Yes.
All right. You have the right to a trial by jury where the Commonwealth would have to prove guilt beyond a reasonable doubt. You waive that right if you plead guilty. Do you understand?
Yes.
Very good. Do you understand that you have the right, with the assistance of an attorney, to confront and cross-examine the people that give evidence against you, as well as the right to put evidence on in your defense? And you waive those rights if you plead guilty.
Yes.
All right. Do you understand that you have a right of appeal and you waive that right if you plead guilty?
Yes.
Okay. Mr. Galinsky, do you feel like you're under the influence of anything today?
No, sir. I'm in rehab.
Okay, I understand. I just have to ask, do you feel like do you feel like your judgment is impaired for any reason?
No, sir.
Are you having any difficulty hearing me?
No, sir.
All right. Do you feel like you have been threatened by anyone to try to get you to plead guilty?
No, sir.
The Commonwealth has made the following recommendations, or promises to make the following recommendations on your plea of guilty to possession of a controlled substance, first degree, first offense. The Commonwealth would, I'm sorry, I got to flip the page. The Commonwealth would recommend a sentence of 2 years on a plea of guilty to possession of drug paraphernalia, a Class A misdemeanor. The Commonwealth would recommend 12 months. On a plea of guilty to DUI first offense, a Class B misdemeanor, the Commonwealth would recommend 30 days. And the DUI sanctions, which include but are not limited to a DUI alcohol counseling program a license suspension, a service fee, and a possibility of fines and court costs. The Commonwealth would agree on your plea to those three charges, to make those recommendations, as well as to dismiss the charges of open container and failure to illuminate headlamps. Is this what you understand that the Commonwealth is recommending in this case?
Yes, sir.
Other than what you and I have just been talking about, has anyone promised you anything to try to get you to plead guilty?
No, sir.
All right. Are you telling me here today that you are pleading guilty voluntarily and of your own free will?
Yes, sir.
Mr. Galinsky, are you acknowledging to me that on or about October the 11th of 2020 in Barron County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes, sir.
Are you also acknowledging to me that at that same time and place, you operated or were in physical control of a motor vehicle while under the influence of a substance or combination of substances that impairs your ability to drive?
Yes, sir.
All right. Mr. Galinsky, I'm going to accept the plea, or I'm sorry, your plea of guilty and the Commonwealth's recommendation.
Okay.
Yes. Okay. Gotcha. So the recommendation of the Commonwealth, because you are in custody is, or I mean, not custody, because you're in treatment, the recommendation of the Commonwealth is that you would just be on supervised probation, and instead of getting an assessment for treatment and all that, since you're already doing treatment, they would just change that recommendation to just be to successfully complete the program that you're doing. Okay.
Okay. Thank you, sir.
All right. Well, hold on.
Okay.
Let me finish this part and then you can ask me whatever you want to ask me.
Okay.
All right. So, Mr. Galinsky, well, listen, go ahead. Ask me what you want because it might change what I say.
I took a DUI class down here. I don't know if they got the papers at the courthouse or not, but it was through the DUI program here in Bowling Green.
Yeah, I don't know either, but any program that you take that satisfies the DUI requirements, they send that into the transportation cabinet. So if they have sent it into the transportation cabinet and they give you a clean bill of health, then you're in good shape.
Okay, yeah, that's what I was wondering.
You'll just
Okay.
have to follow up on that to make sure that it counts.
Okay.
All right. So how long are you planning on being in that program there?
Until June 27th, and then I got to go to federal court for
All right.
parole violation on this charges right here.
All right. So what should he do since he's in that Mark Center? Should he talk to them probation over there?
How do you get it ran concurrent with your federal parole?
How do I get what?
How can I get it ran with my federal parole? I have to talk to my parole officer.
Yeah, that'll be up to your federal guys.
Okay.
Yeah. We sure don't. We sure aren't going to object to that. I mean, it's.
Yeah, because that's what I'm gonna have to do, I guess. It's
Yeah.
Probably because I might go back to prison. That's what I'm trying to figure out. On this federal charge, because of this charge, I might go back to federal prison. I'm not sure yet.
Yeah, let's hope not. All right. So I'm going to sentence you in accordance with this agreement to 2 years, grant your request for probation under the terms that we just talked about. And I'll waive your fines and your court costs. What you're going to need to do is normally you have to go in and meet with probation. They have a probation officer, state probation officer that'll come out of that Bowling Green office and come over there and meet with you. We're going to send them an email so that they know that they need to meet with you there in the Mark Center, and they'll take care of it on that end. You just need to do what they tell you when it comes to reporting, okay?
So these fines is $1,600 fine on here. I don't got to pay it.
No, I'm going to waive that.
Okay, thank you, sir. So I don't know, no fines, just probation.
Yeah, well, you will. Yeah, I forgot you have a DUI. You'll have a service fee, which is $425, but I'm going to give you a year to pay that. So unless you get revoked, that should be doable.
All right. I see. So it's just $425 all y'all,
Yeah,
the Barron County,
yes, sir.
$425 and $200 fines and costs. So it's
No,
$725.
I'm waiving the fines and the court costs. It's just that $425 service fee. I can't waive that, so I have to make you pay that, but not the other.
Okay. So I'm done with y'all. I don't gotta come back, see y'all no more.
You don't have to come back and see us anymore as long as you know, keep your nose clean, okay?
Yes, sir. Thank you much.
All right, thank you.
Have a good day.
All right. Let's see. I've got all kinds of priority clients. Yes, sir. Well, probably. Unless you're speaking. Who do I have in? Cody DeWitt. I thought we. Why did I think that? Huh? No, I was asking about Warren County because I thought they just joined and yeah, and then I've got Rotor on here too. So got two priority clients to deal with after this one. Mr. Ward, raise your right hand, okay? Do you swear to tell me the truth, so help you God? All right, Mr. Ward, in this case, it appears, let me go through this real quick, but it appears that the original charge was promoting contraband in the first degree. The offer of the Commonwealth is to amend that to second degree, which takes it from a Class D felony to a Class A misdemeanor. Is that what you understand? Okay. Have you talked to your attorney about that offer? And do you feel comfortable that you have had sufficient time to discuss that with him? You understand that your rights include the right not to incriminate yourself, which is sometimes called the right to remain silent, the right to have a jury trial where the Commonwealth has to prove guilt beyond a reasonable doubt, the right to confront and cross-examine witnesses as well as to put on your own evidence, and the right to appeal. All right. And do you understand that if you plead guilty, you waive those rights? All right. The Commonwealth's offer, as I mentioned, was to amend this from a D felony to an A misdemeanor and to recommend a sentence of 12 months plus a fine of $500 and court costs, and agree to probate that sentence for a period of 2 years. Is that your understanding of what the Commonwealth agreed to do? Yes. All right. And have you been promised anything other than what you and I just talked about? Anybody threatened you to try to make you plead guilty? All right. Are you acknowledging that on April 20th, 2019 in Barron County, Kentucky, you knowingly introduced dangerous contraband into the Barron County Correctional Center, Barron County Detention Center? Okay. I better give you that back then. All right, where we go from here?
Well, we had an agreement here, Joe's. I like Mr. Brown to talk to him for a few minutes. We can just give up.
Oh, that's fine with me. I mean, I can't look like I'm trying to convince him into doing something. I mean, that's.
Maybe he misunderstood. I think maybe there was misunderstanding. If we could go through the quick book again and give it one more chance.
Okay. I mean, what? Okay. Mr. Ward, as I said a minute ago, the Commonwealth is agreeing that if you plead guilty to the amended charge of promoting contraband in the second degree, it will recommend a 12-month sentence probated plus a fine and court costs. Do you understand that that is the recommendation of the Commonwealth? And have you agreed to accept that recommendation of the Commonwealth and enter a guilty plea accordingly? All right. Do you feel like I'm making you do that? Do you feel like anyone else is making you do that? And has anybody threatened you or put any pressure on you to try to get you to do that? All right. I mean, it's not like you're a pro at this. So, maybe you just misunderstood what I was saying. I don't know. But the essential facts would be that you would be acknowledging that on or about April 20th, 2019 in this county, Barron County, Kentucky, you committed the offense of promoting contraband in the second degree, a Class A misdemeanor, when you knowingly introduced dangerous contraband into the Berrien County Detention Center. Are you telling me here today that you admit that? Okay, all right, very good. Mr. Ward, then I'm going to accept that. Was this a conflict case or? Okay, all right. Mr. Ward, I'm going to accept your plea of guilty today. And I am going to, because this is a misdemeanor, there wouldn't be any reason to, or any requirement to sentence on a separate date. So I'll go ahead and grant your request for probation. I'll sentence you to 12 months, probate that for 2 years. It's not supervised by probation and parole. And because you have appointed counsel, I will waive your fine and your court costs, okay? All right, so basically unsupervised probation means that you have the following conditions: that no new arrests or violations of the law, don't get convicted of any crimes. All right, you don't have a reporting requirement that you have to report to probation and parole or anything like that. You just, stay out of trouble. After 2 years, it'll be, your probation will end, okay? Yeah, did you have things confiscated when you got arrested? Or you're just saying because you had a charge pending? Yeah, yeah. Well, this case does not make you a convicted felon. So this case doesn't have any effect on your ability to hunt or have firearms or anything like that. Okay? All right. Do you have any other questions? All right. You're good to go. Thank you. Jeffrey Parker. Okay.
We need a trial date in the state. We're not able to resolve it.
Okay.
Trials that were set, they didn't resolve it. This was so far down the line that Mr. Brown and I agreed on ahead of time that either one of us would appear in the trial.
Okay. Yeah, I don't have any idea. The best that I can tell you guys is that between the priority things, the in custodies, the murders and the rapes and the child victims, I don't have anything really for about a year. I can double it up onto something else and we just hope that it works out. Hope the other cases resolve and then we can try it. Or if you want me to set something that would be the first thing that I set, it's going to be.
I'd be okay with that. Just setting the first available date, and if it doesn't work out, then we can.
Yeah, because as you might imagine, we hadn't tried anything for 15 months. So everybody that wants a trial, which people that are in the same boat that you are, and then plus those cases, all the trials that we already had that got canceled for 15 months.
And I'd like to get the person to say, I understand, of course, figuring out this is the 2018.
Oh, listen, I'm with you. I understand. Right now, I could probably set this. This is the first time I've got a case that I don't have at least 2 trials set at the same time, September 15th and 16th. if you think this would need 2 days. I have a civil case set then.
I don't know that we would need 2 days.
Yeah,
I mean, I don't know.
well, I mean, I might as well take 2 because I've already got it.
It's fine. I was gonna say, we got some of the witnesses.
Yeah.
I don't know
If that case settles, it's 2 weeks long. So if it settles, it ain't gonna matter whether I'm getting a day or 2 for you all. That's all. It takes up 2 whole weeks, that other case. So we can just call it 15th and 16th. What we probably need to do is put a pretrial on, like maybe 3 weeks before, because I'll know, I should have a better idea if that other case is gonna go by the time we get there, although some of those go right up to the edge before they.
So you're saying there's a civil case that's already set?
Yes, I'm saying that from the 15th to the 24th. I actually have 2 cases back to back, but one of them's only the second week of that. So this will be the doubled up case on the first week. 9, 15, and 9, 16. Pre-trial, let's call it August 30th. One o'clock. All right. And so we will put that down. August 30th at 1 o'clock will be our pretrial. And I'm not, I know that I don't have that on there because I think it's going to get resolved. I have it on there because hopefully I'll know whether that other case is going to be settled by then and we can figure out what we're going to do. Okay? That other case is one that, well, I hope they settle it because there's a lot going on in that case. All right. Thank you. All right, let's, if you all don't care, let me get, I think I've got Rotor Correctional Complex on here, and I believe Mr. Davis is here for that one, and I believe he's available.
Yes, sir. Thank you.
Saw him turn his mic off, so. All right. All right. Yeah, that's Mr. Booth. All right, very good. Here we are with 19 CR 667. And this is Mr. Booth. Is that right?
Yes, sir.
All right. Your attorney is on here. Prior to today, he tendered to me some plea-related documents. Is it the case, sir, that you have a plea agreement worked out and wish to enter that today?
Yes, sir.
All right. Will you raise your right hand for me, please? Do you swear or affirm that you will tell me the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Let me get through your papers here. And all right, here we go. So right here, I have a document that is entitled a motion to enter a guilty plea. Can you see that?
Yes, sir.
Okay. The second page of that has a signature line on that. Do you see that?
Yes, sir.
Okay. Did you go over this document and discuss it with your attorney?
Yes, I did.
Did you authorize him, if I understand correctly, just because of you being in a state penal facility and him being where he is, getting in person was hard. So did you authorize him to sign that on your behalf?
Yes, sir.
Did you only do that after you were convinced that you understood the motion to enter a guilty plea and what it contained?
Yes.
Okay. The offer from the Commonwealth is also right here in my hand, and it, I believe, has your signature on it as well, maybe in the same fashion. Let me get over there and look. Yeah, here we go. All right. So this is the front page of that document, just so that you can see what I'm looking at. It's got your name, your case number,
Yes, sir.
charges, et cetera. And then that is the signature page, and it looks like the Commonwealth forgot to sign it. We'll get them to sign it before we enter it, but that's the signature, that's your signature line right there.
Yes, sir.
So did you go over this document and discuss it with your attorney as well?
Yes, sir.
All right. And are you comfortable that you understand that document?
Yes, sir.
All right. Same question. Did you authorize your attorney to sign your signature on it?
Yes.
Okay. And in doing that, are you indicating to me that you feel comfortable with that, with your understanding of that document?
Yes, sir.
Okay. Specifically, let's talk about the motion to enter a guilty plea for a moment. Do you understand that you do not have to enter a guilty plea, and that if you do so, that has to be your own decision that you come to voluntarily?
Yes, sir.
Do you feel like I am making you plead guilty?
No.
Do you feel like anyone else is forcing you against your will to plead guilty?
No, sir.
You understand that if you plead guilty, you waive the right not to incriminate yourself.
Yes, sir.
You also waive the right to have a trial by jury where the Commonwealth would be responsible for proving guilt beyond a reasonable doubt.
Yes.
Okay. You waive the right to, I've got like 3 versions of each one, so just pick one. You waive the right to put evidence on in your defense. You
Sir.
understand? All right. Do you understand that you waive the right with the assistance of an attorney to confront and cross-examine the people that give evidence against you?
Yes, sir.
And finally, do you understand that you waive the right to appeal the outcome of your case to a higher court?
Yes.
Very good. Now, Mr. Booth, do you feel like you're under the influence of anything today?
No, sir.
Do you feel like your judgment is impaired for any reason today?
No, sir.
Are you satisfied that you can hear and understand me?
Yes, sir.
Are you satisfied with the, thank you, with the ability that you've had to communicate with your attorney as well?
Yes, sir.
All right. I am going to start looking through this motion or this offer on a plea of guilty, and I'm going to discuss that with you. So listen real close so that I make sure that both of us understand it the same way before we get done, okay?
Yes, sir.
Count 1 is possession of a handgun by a convicted felon. That is a Class C felony with a penalty range of 5 to 10 years. On a guilty plea to that charge, the Commonwealth would recommend a sentence of 7 years. Counts 2 and 3 are your co-defendant charge. They don't apply to you, so we won't discuss them further. Count 4, possession of a controlled substance, first degree, second offense. That is a Class D felony, a range of 1 to 5. The Commonwealth on a plea of guilty would recommend a 3-year sentence. Count 5, possession of a controlled substance, second degree, is a Class A misdemeanor. The Commonwealth would recommend a 12-month sentence. Count 6, promoting contraband in the first degree, a Class D felony. The Commonwealth would agree as part of the plea offer to dismiss that charge. Count 7, tampering with physical evidence, a Class D felony. That is a 1 to 5. The Commonwealth on a plea of guilty would recommend a sentence of 5 years. Count 8 is a co-defendant charge. Count 9 is driving on a suspended license, a B misdemeanor, which the Commonwealth would, on a plea of guilty, recommend 90 days. Count 10, marijuana possession, a B misdemeanor. The Commonwealth would recommend 45 days. Count 11, persistent felony offender in the second degree. That is a sentence enhancement provision. On your plea to the other charges as indicated, the Commonwealth would agree to dismiss that charge. Therefore, the recommended sentences of 7 years on count 1, 3 years on count 4, 12 months on count 5, count 7 would be 5 years, 9 and 10 would be 90 days and 45 days. All of those would run concurrently for a total recommendation of 7 years. The conviction would also result in forfeiture of a weapon or weapons and ammunition seized at the time of the arrest. This sentence would be consecutive with any previous sentence. Is this what you understood the offer of the Commonwealth to be?
Yes, sir.
And other than what I just talked to you about, have you been promised anything to try to get you to plead guilty?
No, sir.
And again, let me ask you, just to be safe, has anyone threatened you to try to get you to plead guilty?
No, sir.
All right. Are you telling me that you are pleading guilty voluntarily today based upon what you have just heard from me about the offer from the Commonwealth?
Yes, sir.
All right. Mr. Both, do you acknowledge that on August the 30th, 2019 in Barron County, Kentucky, you committed the offense of possession of a handgun by a convicted felon when you possessed, manufactured, or transported a handgun having a prior felony conviction which has not been the subject of a full pardon by either the governor or the president?
Yes.
All right. Are you acknowledging that at that same time and place, you were in possession of, knowingly and unlawfully in possession of hydrocodone, a Schedule II controlled substance, and you have at least one prior conviction for possession of a controlled substance?
Yes, sir.
Are you also acknowledging at that same time and place, you were in possession knowingly and unlawfully of buprenorphine, a Schedule III controlled substance?
Yes, sir.
Okay. Mr. Both, are you acknowledging that you committed the offense of tampering with physical evidence on or about August 30th, 2019, when believing that a official proceeding had been or was going to be instituted, you concealed, removed, destroyed, or altered physical evidence which you believed could or was going to be used, and it could be or was going to be used or produced in the official proceeding with
Yes,
the
sir.
intent to impair the availability of the evidence?
Yes, sir.
Okay. Are you acknowledging that at the same time and place, August 30th, 2019, you operated a motor vehicle on a public highway knowing that your license had been suspended, and that was in Barron County, Kentucky?
Yes, sir.
All right. Are you also acknowledging that at that same time and place, you knowingly and unlawfully possessed marijuana?
Yes, sir.
All right. I believe we've covered it.
Can I ask you a question, Your Honor?
Yes, you may.
From August 30th of 2019, I'm getting credit for them days up to this day right now, right?
What I believe, if you have been in the custody of the state, serving a state sentence or Department of Correction sentence, and you have received custody credit on that Department of Corrections sentence, you won't get double credit against the two sentences, for the same period of time that you've been in custody.
But I never made bond, and I mean I've been locked up the whole time because of these charges that I'm pleading guilty to right now.
I understand. I'm just telling you the way I believe that that's the way the Department of Corrections will calculate your sentence. Because they'll calculate how your sentence gets served based upon the internal regulations and so forth that they have for counting up custody.
Mr. Booth, I believe you're going to get credit for every day you've served. If you think something is wrong, let me know. We'll file a motion before the court.
'Cause I've been locked up since.
He's definitely going to get credit for every day that he's been in custody. I just don't, I'm trying not to, I don't want to mislead him and tell him that he'll get credit on both cases for the same day, every day that he's been in there, because I don't know that they will do that.
See, September 24th, I was in front of you, Your Honor, and y'all revoked my 2 years I had with y'all. And 3 days later, Hart County revoked 10 years that I had with them as a total of 12 years. But I've never been out. I know on bond or nothing. I've been locked up from these charges I'm pleading guilty for today.
I understand. And like your attorney is saying, if you get your time credit sheet and you disagree with the way that your time is being calculated, you can, there's a process that you can challenge that.
Okay.
Okay?
All right.
All right. It looks like you have also, in the course of executing these other documents, you had filed a motion asking to waive a pre-sentence investigation and go ahead and have your sentence imposed today. Is that right?
Yes, sir.
Okay. And that is fine with me. I will, we're certainly allowed to do that because you're in custody. So I will go ahead and accept your plea of guilty today. And I'm going to waive your fines and your court costs and sentence you in accordance with this agreement to a 7-year sentence, which would be by the terms of the agreement and statutory provision would also require that it be served consecutive. Do you understand that?
Yes, sir.
All right. Do you have any other questions that I can answer for you or attempt to answer for you at this point?
No, sir.
Okay. Mr. Davis, anything on your end?
No, sir. Thank you.
All right. All right. Good luck to you, sir. Okay.
Thank you, sir.
All right.
Thank you, Your Honor. I believe that concludes my business.
All right. Thank you. Good. Have a good day.
Thank you, sir.
Okay. So Crystal. I'm going to hand you this. There are 2, if not 3. But only one of them has been signed by the company. So let's pick the one that John signed, and we can just get rid of everything else. All right, let's see. Ms. Gardner, you want to do, I know Warren County Jail, they need to go. That's Mr. DeWitt. Oh, okay. All right. Cody DeWitt.
Yes, sir.
Okay. That is that Greg. Is it his? Is Cody DeWitt yours? Oh, okay. Mr. DeWitt, we're gonna have to come back to you. Your attorney stepped out. She's talking to a client and she stepped out. So I'm gonna have to call you when she gets back in here.
Okay, thank you.
All right. Those other 2 guys he was with had multiple indictments. I just thought he did too.
Another F case on the phone.
He doesn't have another CR case.
Not yet.
Okay.
But one F coming back. And I really like
Jessica Bird.
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 You know, bird, you know, like that. All right. Okay. Miss Bird, right? Can you raise your right hand for me, please? Do you swear or affirm that you will tell me the truth, so help you God? All right, thank you. Miss Bird, I have here a motion to enter a guilty plea that looks like it was signed today. Is that right? Did you read through that before you signed it? Okay. I also have an offer from the Commonwealth. Also looks like it was signed today. Did you read through that before you signed it? All right. With respect to both of those documents, do you feel like you understood them and anything that you did not understand? Do you feel like you had adequate time to talk to your attorney? Yes? Okay. I'm sorry. I just don't know if the camera's picking you up when you nod. So I wanted to make sure that you said it out loud. Okay. All right. Ms. Bird, do you understand that you have a right to remain silent? And sometimes that's called the privilege against self-incrimination or the right not to incriminate yourself. If you plead guilty, you waive that right. Do you understand?
Yes, sir.
Okay. You have the right to have a trial in front of a jury with the Commonwealth having the burden to prove guilt beyond a reasonable doubt. If you plead guilty, you waive that right. Do you understand?
Yes, sir.
Okay. You have the following rights as well. You have the right, with the assistance of your lawyer, to confront and cross-examine the people that give evidence against you, and the right to put evidence on in your own defense. Do you understand that you waive those rights if you plead guilty? And finally, you have the right to appeal, and you waive that if you plead guilty. Do you understand? Okay. Now, as you stand here today, do you feel like you're under the influence of anything?
No.
Do you feel like your judgment is impaired for any reason?
No, sir.
Are you satisfied that you've had adequate time to talk to your attorney? Have you and he been able to communicate?
Yes.
Okay. And can you understand me?
Yes.
All right. Thank you. Now, do you feel like anybody is making you plead guilty?
No.
Okay. This is the offer from the Commonwealth as I understand it. And it is as follows. Count 1, possession of a controlled substance, first degree, first offense. That the Commonwealth, that is a Class D felony. The Commonwealth would recommend a sentence of 2 years on 2 years and a possible fine and costs. On count 2, that is rear license plate not illuminated, the Commonwealth agrees to dismiss that charge on your plea of guilty to count 1. Therefore, the total recommended sentence would be a 2-year sentence. And the Commonwealth agrees to pretrial diversion of that sentence under supervision of probation and parole for I suppose it would be a period of 2 years.
It would be, Judge. It was initially a drug court offer, so.
Okay.
At the time.
Yeah.
But yes.
I was kind of just making a logical leap there because that's about how long it would take. And a condition of that would be that you get an assessment for any kind of substance abuse issues and that you comply with the results of that assessment as part of your probation. Do you understand that?
Yes, sir.
Okay. Other than that, has anyone promised you anything to get you to plead guilty?
No, sir.
Has anyone threatened you to try to make you plead guilty? Do you feel like I am making you plead guilty?
No, sir.
All right. Ms. Byrd, are you acknowledging that on November 27, 2019 in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine?
Yes, sir.
Okay, then I'm going to accept your plea of guilty today. The only thing we don't have is a pretrial diversion order. Since she didn't go to drug court, we normally would do which I understand why we didn't, because it was a change of pace. Is it possible that you could get that done and sent? Oh, can you get one done right now? What do you think about that, Mr. Barry? Could she hang around for a few minutes and yeah, that'd save you another trip back up here. If you can wait a few minutes, we'll get that done. And then Mr. Barry, I want you to look over this and if you agree, you can sign it and I'll bring you back up. We'll go over it, make sure you don't have any questions or anything like that, and then we'll be done. Okay?
Sounds fine.
All right. Thanks.
Thank you.
Ms. Myers, is there any way, I've got Warren County on here and they need to get, the one person I have in Warren County is yours, Cody DeWitt. All right, Mr. DeWitt. I think we're back. I don't know if we have anything we can do. It might be the case that he's got another charge that's on its way up that hadn't been indicted yet. Does that sound familiar?
There's, no, I don't know. He has only charged stemming from this. It's just indicted. I think they have charged him.
Oh, you know what? Yeah, that is right. The reason I even remembered that is because I think I got an agreed order to dismiss that because in lieu of the Warren County prosecution. And for some reason I remembered the case, but I didn't remember signing that order. So, yeah. So that other case, that other F case in Barron County has been dismissed. Yeah. Yeah. Okay.
And Bradley Miller was, yeah, something about.
Yeah. I knew it was rattling around in my head. So,
We have some discovery of all this.
oh, sure. Sure.
I don't believe we're having trials this week, so I think I can actually contact this week if I can send this over.
They don't let, you can't go over there you can't go over there on a weekend or,
They made a special arrangement for one case that I had, and I had like special clearance through the jailer. So I have to call and set it up.
If I can get a phone number, I can call her on Tuesdays and Thursdays.
Yeah, that's, the problem is, like, if he calls me, I may be in Burke County Jail
Right.
or Barron County Jail, so he can't always catch me and we end up.
sure.
I just want to number to contact her.
I can schedule an appointment through our coordinator this week. I'm fairly certain.
All right.
because this is-
Yeah.
I don't-
She feels fairly sure that she'll be able to get over there and see you in the next few days because she doesn't have any trials scheduled or anything like that this week. So
I can at least see him on Zoom, Your Honor.
I suppose if you feel that strongly about that, we could just put it on next Monday. I don't know if you, I don't want to push it, but we found out today that, you know, just because of the way things are scheduled and people being in and out and that kind of thing, that, I mean, you know, a lot of the things that we set today are all the way out into July and starting to get into August because of people not being here and that kind of thing, which is nobody's fault. I'm just saying.
If you can meet on this Monday, I'll either schedule a Zoom or be there in person in Warren County. Obviously, I'm limited to their schedule because they get you 30-minute time blocks.
Yeah.
But I feel pretty confident that I can get him to meet with him either by Zoom or by.
Okay.
by another. Your Honor, may I ask the court if for some reason he wishes to stay in office with him being in Warren County, if he gives me permission or directive to sign that, I don't like to make a habit of that, but is that something that the court would entertain to expedite cases?
Yeah. We just did one because the guy was in Rotor and you can't get in to see him and, you know, and I just confirmed it with him that he authorized it and everything. So, I mean, I'd hate to do it all the time, but these are desperate times.
Well, I think it's kind of the rare case that I would do that, but on this particular case, it would be on there in person.
Okay. All right. Mr. DeWitt, I believe she's going to be able to talk to you this week and we're going to put it on next Monday and, you know, hopefully we'll be able to get something done next Monday. Okay.
Yes, sir. Thank you. Have a great day.
All right. You too. See you later. No. Oh, yeah. Yeah. All right, let's see. I have Crystal Powell.
Yes, Your Honor.
I don't know if I've got everybody in here that I need for you, Miss Powell. Is that you? Oh, okay. Miss Powell? Do you have the stuff? I think this is a, no, I do not, but I can get it printed out real quick. All right. That's all right. Okay. Okay. Good deal. Thank you. All right, Ms. Powell, it's going to be a second. Okay. We have to print out some paperwork that I will need to look at to go over with you.
Yes, Your
All
Honor.
right.
Yes, sir.
All right. Okay. All right, Miss Powell, just hang in for a minute. Miss Gossett, how are you?
I'm not saying it's Gossip's fault. We were just able to make contact. I need to get a little more time to see her and my office.
Okay.
That's fine, Judge. I was mainly wanting to see Ms. Gossett complete treatment of the issues there. He's
I think, how long you been?
I completed a 30-day treatment. I have a copy. I don't have it with me, but I do have to speak it out in women's recovery home, and boundaries I'll do that for them. And Rachel, we runs it. She says she has no problem, emailing any type of like, confirmation in a letter or whatever.
Yeah, just have her send you something if you don't care, so you can get that to Mr. Richardson. That's where you were whenever we did your arraignment. Same place, right? Yeah. All right. I tell you, yeah, I mean, we've just got so many things, and one of those days I won't be here. So you want to do July 12th? That ought to give us plenty of time to get a progress update and so forth. So Ms. Gossett, just be sure that you all get to Mr. Brown, whatever it is that he's needing, and that he'll have time to give it to Mr. Richardson, and, you know, you guys can work on maybe resolving things, okay? All right, thank you.
Judge, while we're at it, she had a good, Benton Price, CPT.
Okay, Benton Price? Is Mr. Barry, you're representing you? Yes? Okay,
Judge, this was kind of the same, you know, he was treated when the CPT. I'll be okay with it, because on the same day as possible. So it would be helpful if I could see these complete that.
so, yeah, you probably want to get, are you still over in Owensboro? Yeah. Okay.
I've got 2 jobs right now, actually. I'm working at Stratus Plastics down there, it's a factory in Morgantown.
Okay,
But I'm putting there tonight because I got a better job offer and I'm going to pursue, I start there Wednesday.
okay. So you want, what you need to do is have those people send Mr. Barry some, you know, some status updates so that they can tell him, you know, whatever you've done and what you're still doing, and confirm all that, so he can talk to your prosecutor here, and maybe, you know, y'all can get some progress on this thing. Let's go July 12th, okay? 1 o'clock. All right, thank you. Just do what Mr. Barry tells you. All right, Ms. Powell. We're back. This is Crystal Powell. It's a rocket docket case. So it was probably Miss Hill did. Yeah. All right. Miss Powell, can you raise your right hand for me? Do you swear to tell me the truth, so help you God?
I do, sir.
All right, thank you. This is your a motion to enter a guilty plea. Can you see that?
Yes, sir.
Okay, it's got your name on it right there. If you go over here to this page, it's got your name. It's not your actual signature. It's, you know, a virtual signature, I guess we would say. But did you authorize Ms. Hill to sign your name or virtually sign your name to that?
You did, Your Honor. Yes, sir.
And did you read it before you did so?
We discussed the plea agreement here in person at the jail
Okay,
Friday before those papers were given to me. Yes. I had a chance.
okay. So she went over it with you and you all discussed what you were doing. Is that right?
Yes, sir.
Are you satisfied that you have had all the time you need to discuss that with her?
Well, Your Honor, to be honest, I've tried to contact Ms. Hill. Unfortunately, the phone is only available here when there's not court or transports going on, as you can understand, because I'm in jail. I haven't had a chance to reach her. And I'm just, I'm I wanted to withdraw my guilty plea. I wanted to discuss that with her previous to court, but I haven't had a chance to reach her in order to do that. I apologize for any time that you felt like is wasted in court today. I didn't intend for that to happen. But
Well, there's nothing to withdraw because you haven't entered a guilty plea yet. So, I mean, if you don't want to enter it, we're not going to enter it. That's not a problem.
yes, sir. No, I don't, Your Honor.
Okay, not a problem. So I guess she'll be put back on the district court docket. Is that
Yeah,
right?
if she wants to discuss it further with Ms. Hill, I'll leave this offer as is. It won't be the same offer. We have to go to grand jury. and
Yeah.
indict.
Yeah. Ms. Gardner says, I don't know if you could hear her, that if you want to talk to Ms. Hill, you can. And until your case gets presented to the grand jury, she will have the same offer to you. If it gets presented to the grand jury and you get indicted, you know, it likely won't be the same offer. Okay?
Right, yes, Your Honor. I would like to speak with Ms. Hill more on the issue. It's basically on my background and the offer that was given to me, because I'm already on being offered probation. And I just feel like there was I have no drug background, Your Honor, and I feel like I could have gotten a better offer. I'm almost due to give birth in 6.5 weeks. And this isn't holding me. I've got a release on this case, but I have another case here in Hart County that is pending this case, which is why I'm being held. So I desperately need to speak with my lawyer about this case. Yes, sir.
All right. Well, hey, listen, this is fine. I'm going to put all this stuff in your file, but you know, like I said, you're not withdrawing anything because you hadn't entered it. So it's no problem.
Did she say she wasn't offered probation in this case?
I think she said she was offered probation, but thought she could do better.
Well, the reason why she was not offered pretrial diversion is because she has a conviction out of Hart County.
Yeah,
She didn't have a prior conviction. She wasn't offered.
sure. I mean, she's just going to have to talk to her attorney about that. Yeah. Yeah. I mean, Ms. Gardner says that she did not offer pretrial diversion because you're not eligible for pretrial diversion.
Okay, those are the kinds of facts, Your Honor, that I feel I need to discuss with my attorney, because I'm not sure.
Oh, sure. Hey, listen, nobody's making you do anything. So you don't have to explain why you're not doing it, because I'm not making you do it. Okay.
Yes, sir.
All right. Thank you.
Thank you very much, Your Honor. You have a good day.
You too. Can I finish up? I got two more in Hart County. Can I try to finish them?
Actually, sir, I need to jump off and go to Edmonson County. I'm already 15 minutes late for their court. Can I get back with you as soon as I'm done?
You better believe it. We'll be here.
All right, thank you.
I did give Greg just the bird's diversion.
Yeah, I think she might be looking at it as we speak.
Judge,
Yes.
we had Bethany, can you
Yeah, she's on here.
speak Bergen?
Oh, no.
Yeah, she's on.
No, I just meant, no, like I was talking about a different Bethany, but they're both on here. We got at least two Bethanies.
I just need Steve.
All right. Bethany Steenbergen, are you listening?
Yes, sir.
Huh. I would have sworn you weren't. You had your camera off and everything. I figured she was eating popcorn.
Discussing Ernest Johnson case.
Yeah. Jason Johnson, you know who I'm talking about? Oh, you're on mute.
Sorry. Jason.
Ernest Jason Johnson.
Yes.
You know who I'm talking about?
Mhm.
Yeah.
Greg said that, I guess you've evaluated him and, has a bed date for tomorrow with Hope Haven, is that correct?
He is at Hope House,
Hope House?
Bowling Green. Yes.
And how long, is it a long-term program? Is it?
It is a 12-month program.
Okay.
Is there any way we could push that bed date back till sometime later this week? Because he's got a pending F case. I think we could resolve to do all of that at one time before he
Yep.
goes.
Yep, just let me know when.
Yeah, you all tell me and we can just do a plea. We can get on Zoom and do one just anytime.
I've got some stuff, I know, one with Greg, it's Thursday afternoon, I've got a couple other things.
Yeah, I mean, how long are y'all gonna need to do your papers? Yeah. What about Bethany, if we committed to trying to get this done, let's see, I think I've got some kind of hearing Wednesday morning already at 9:00. Do you have that? No, I've got it. That isn't the one I was thinking of. I've got so many things on there. I've run out of room on my calendar. Yeah, no, there's somebody at Kindle something or another. But it doesn't, I've got so many things on there. They aren't popping up as,
I do that.
oh no, that's next week. Yeah, I've lost my mind. Yeah, no. Yeah, we got Mr. McCarter at 9 a.m. So do you want to do, we could do this.
Somebody can cover.
Yeah. Well, yeah, we'll have to, I mean, I'll have to be.
We're still gonna leave. I think that's it.
Are you?
Yeah, because we sent out everything already at the time Carter got, so we're not changing.
So I'll have this room. Yeah, all right. All right. So do you want to do that, Greg? Do you want to try to do Mr. Johnson on Wednesday morning, and then that way we don't have to put his bed date off very long? What do you think about that, Bethany?
Sounds good.
All right. Fair enough. Thank you. Is he on today?
He is.
All right.
Yeah.
Yes. Oh, you already handed me the file. Huh? 9:00.
This one's coming Wednesday.
Yeah. Past two, that's the 19th, right?
Yes, sir.
All right, so. Yes, sir. Do I feel what? Yeah. Go ahead, I'm sorry.
I've got two cases, Elijah Warren Hunt.
Uh-huh,
I filed plea documents in that case.
okay. Mr. Hun,
And later that day.
She come back about 1:30.
who I'm hearing, that's Johnny. I'm muting you, Johnny. I can't hear you, I muted you. All right, Mr. Hun, how are you today? I'm doing all right. Can you raise your right hand for me? Do you swear or affirm that you'll tell me the truth, so help you God? All right, thank you. So, Mr. Hun, you got two cases on here, and Mr. Richardson indicates to me that you have an agreement in both cases. Is that right? All right. Are you prepared to go forward and enter a guilty plea today? Do you feel like you're being forced to do that by anybody? Do you feel like your judgment is impaired today for any reason? No? Are you thinking straight? Straight as ever? Yeah, okay. All right. I got you. So in no particular order, because I'm not, it doesn't really matter which one of these we talk about first, but 19 CR 662 looks like you have signed a motion to enter a guilty plea. Looks like that was signed, I don't know, a week or so ago, and you and Ms. Myers both signed that. Is that right? And similarly, in 20 CR 75, at or around the exact same time, you signed a guilty plea motion in that other case too. All right. Did you read over those before you signed them? Did she go over them with you? Did she read them to you or explain them to you? Okay. Was she available to answer questions if you had any about what something meant or, if you weren't sure about anything, did she answer them for you? Okay. Are you satisfied that you've had the amount of time that you would need to talk with her? You are? Do you feel like anybody's forcing you to do this or pushing you into this without giving you enough time? No? All right. Do you understand that you have the right not to say anything that can be used against you? That's called the privilege against self-incrimination. Sometimes you hear it called the right to remain silent, right? If you tell me that you're guilty, if you enter a guilty plea and you tell me that you're guilty, then you're waiving that right. Do you understand? Because I'm not going to make you say anything, but to plead guilty, you have to tell me that you admit to something. And so you're voluntarily doing that and waiving your right not to tell me anything. Does that make sense? Okay. You would, if you wanted to, you could have a trial. You have a right to have a trial in front of a jury where the Commonwealth would have to prove guilt beyond a reasonable doubt. If you plead guilty voluntarily, you waive that right. Do you understand? You waive the right to, with the help of your lawyer, to confront and cross-examine the people that give evidence against you, right? Okay. And you waive the right to put evidence on in your own defense, right? Do you understand? Okay. And finally, you have a right to appeal the outcome of your case to a higher court, and you waive that if you plead guilty. Do you understand? Okay. Very good. Mr. Hunn, let's talk about 19 CR 662. In that case, your charges are burglary in the second degree and assault in the fourth degree. Burglary in the second degree is a Class C felony. Assault in the fourth degree is a Class A misdemeanor. The Commonwealth, as part of its plea offer in that case, agrees to amend the burglary in the second degree to burglary in the third degree, which takes it from a C felony down to a D felony. And if you plead guilty, recommends a 3-year sentence. On assault in the fourth degree, which is a Class A misdemeanor, the Commonwealth recommends a 12-month sentence. The 3 years and the 12 months would run what we call concurrently or at the same time for a total of 3 years. The Commonwealth agrees to put you on probation. So your sentence, instead of having to serve it out, you would be probated under supervision of probation and parole for a period of 5 years on the condition that you follow the rules of probation and parole, which you probably know include, you report to them when they tell you to, you tell them where you're living, if they come visit, you have to let them in, you stay out of trouble, you don't get any, you don't use drugs and alcohol, you might get random drug screens, et cetera, right? And specifically in this case, a condition would be, based upon the nature of the charges, you would expect this, a condition would be that you don't have any contact with the victims in the case or the families thereof. Do you understand that? All right. What I just told you, is that what you thought you were agreeing to? All right. Other than what I just told you, have you been promised anything else to try to get you to plead guilty? All right. And has anybody made any threats against you to try to get you to plead guilty against your will? All right. Mr. Hunn, are you pleading guilty voluntarily today? Are you acknowledging to me that on August 14th, 2019, in Berrien County, Kentucky, you committed the offense of burglary in the third degree when you knowingly entered or remained unlawfully in the residence of Joshua and Ashley Wide with the intent to commit an offense? Okay? Is that yes? All right. I just want to make sure that, because my camera, I don't know if it's picking you up, so I wanted you to answer loud enough that I could hear you. Also, are you acknowledging that you committed the offense of assault in the fourth degree when you intentionally or wantonly caused physical injury to Mr. White? Okay. All right. Then I believe we've got that one taken care of. Let's move on to the next one. It is the Commonwealth is making the following offer in this case. This is 20 CR 71. Count one, excuse me, strangulation in the second degree. That is a Class D felony. On a guilty plea, the Commonwealth would recommend a sentence of 3 years. Count two, unauthorized use of a motor vehicle in the, or first offense. That is a Class A misdemeanor. On a plea of guilty, the Commonwealth recommends a sentence of 12 months. Count 3, assault in the 4th degree, domestic related. That is a Class A misdemeanor. The Commonwealth agrees to recommend a sentence of 12 months. Count 4, possession of drug paraphernalia. That is a Class A misdemeanor. The Commonwealth recommends a sentence of 12 months. Count 5, possession of marijuana, a Class B misdemeanor. The Commonwealth recommends 45 days. Count 6, driving under the influence, first offense with an aggravating circumstance. The Commonwealth agrees to recommend a sentence of 30 days, a fine, a service fee of $375, 90-day license suspension, or whatever, I guess, whatever the cabinet, the transportation cabinet administers, right? First offender DUI or substance abuse counseling. And the Commonwealth also recommends, as per the statute, community service. The count 7, license not in possession. The Commonwealth agrees to recommend a 90-day sentence. That's a B misdemeanor. Count 8, no seatbelt. They'll dismiss that one. The total recommended sentence is 3 years plus those DUI consequences that we talked about a minute ago with the license suspension and the counseling and so on. The Commonwealth also agrees to probate this sentence for a period of 5 years on the same conditions and terms as before, and with the additional condition that probation and parole will do a substance abuse assessment with you. And if they recommend that you do any kind of treatment or anything, that'd be part of your probation too. Okay? All right. You would also have the condition not to have any contact directly or indirectly with the victim in the case.
Judge, I wanted to add that we had spoken to Ms. Martha about this. Normally, it's not something we probate with strangulation, but she was okay with this deal. That's why
I'm not trying to be nosy, but I mean, were they like in a romantic relationship? Is that the thing?
Yes.
Yeah.
It was an ongoing issue.
Yeah. The reason I'm asking is because it's a family thing. And when it says no contact with the victim or the family, I wanted to make sure that they weren't family members, because then that gets things confused. But if they were,
They're not together.
I shouldn't say family member. They aren't related to one another by blood. In other words, they were just a guy and his lady friend. Okay. All right. So, Mr. Hunn, the sentence in this case and the sentence in the case that we just talked about, the offer from the Commonwealth would include that they run concurrently with one another. So do you understand everything that we're talking about in this case? All right. And is this what you thought you were agreeing to in this case? All right. Are you acknowledging to me that on November the 17th, 2019 in Barron County, Kentucky, you, without consent, wantonly impeded the normal breathing or circulation of Diana Barflow by applying pressure on the throat or neck or blocking the nose or mouth, constituting the offense of strangulation in the 2nd degree? All right. Are you also acknowledging that at that same time and place, you were operating a motor vehicle or exercising control thereof without the consent of the owner or person having the legal possession thereof? Are you also acknowledging that you were operating that motor vehicle or in control thereof while under the influence of a substance or combination of substances that impairs your ability to drive, and your blood alcohol content was greater than 0.15 as measured on a breathalyzer, right? All right. Are you acknowledging that you committed the offense of assault in the 4th degree, domestic violence related, when you intentionally or wantonly caused Diana Barflow a physical injury? All right. Are you acknowledging that on or about November 17th, 2019, you knowingly and unlawfully possessed drug paraphernalia? And finally, are you acknowledging that you were operating a motor vehicle and you didn't have your driver's license in your possession? Right? Okay. You forgot about that one. Yeah. All right. All right. Mr. Hunn, I'm going to accept your plea of guilty to both of these things here today. I believe that we can get you set up with probation and parole so that they can do what we call a pre-sentence investigation. They prepare a report. We all get to look at it. We'll come back and have your sentencing at some point in the future after those things have been done. And, then we'll be able to decide what your sentence is going to be, based upon what you've agreed to. Yeah, PSI. I call it a pre-sentence investigation, but usually we call it a PSI just because, it's easier. Okay. All right. So let me, I'm accepting your plea of guilty in both cases. Let's set this sentencing for 10 o'clock on June 28th. Oh, are you going to be here on June 28th? Okay. 10 o'clock on June 28th. You got a probation officer right behind you. He's going to tell you what he needs you to do, but it's probably going to involve going out to the probation office and filling out some paperwork where they can do this PSI report. Okay? All right. Do you have any questions right now? Okay. You're out on bond. You've been out all this time. You're going to, you remain on bond until we sentence you. So, mind your P's and Q's, and we'll see you on June 28th. Okay? All right. Yeah. Well, you just, you feel like you remember it, but you don't always remember it. Hell, I almost said a bunch of stuff today when I wasn't here. Yes, sir. Jessica Bird. All right. So I have already accepted Ms. Bird's plea of guilty. This is her agreed order of pretrial diversion. Ms. Bird, I'm sorry. Did you have the chance to look this over?
Yes, sir.
And if you had any questions, did you get to ask Mr. Berry?
Yes.
All right. Do you feel like you understand this? You've signed it, right?
Yes.
Okay. You have any questions you want to ask me?
Yes, sir.
All right. So when you signed it, it had three blank places on it, 4 blank places on it. One of them is for the court costs. And I always give you 6 months on a pretrial diversion to pay the court costs. It's $165. So, that's under $30 a month to get that paid. All right. I'm not going to fine you because you're not being sentenced, because that's the whole essence of the pretrial diversion. So that $165 is all I'm going to be ordering you to pay. There is a possibility of a deferral fee that I could order you to pay, but it is generally my practice not to order that. So I'm putting a 0 on that one. The other date is today's date, or the other blank is today's date. So I'm filling that in with, as you might imagine, today's date. And finally, the last blank is my signature. So when I sign it, we'll be good to go. All right. Before I sign it, is there anything else you want to talk about or any questions you want to ask me? Okay. Then I'm going to accept your pretrial, your agreement as to pretrial diversion, and we'll get that entered.
Can I get a copy of that? That's all I'm
Yeah. We'll mail it to you after it gets entered, or we'll mail it. I guess they may mail it to you. I don't know. Do you mail it to the attorney? The only other thing you got to do, it was supervised by probation and parole, right? Yeah. So the only other thing I need her to do, because our probation officer skedaddled out of here, is to wait until he gets back so she can talk with him and he can tell her where and when to report out to the probation office. I keep telling you we're done, and then I ask you to wait. So I apologize, but he's that fella that was sitting right there and right behind you. And when he comes back in, you can just tell him that you're on pretrial diversion and what does he need you to do. But I believe he's going to tell you to go out to the probation office tomorrow. There he is right there. Supervised pretrial diversion. Does she just come out there tomorrow? Oh, boom. He's got it ready. All right. See you. Good luck. Oh, yeah. Let's go. Call him.
We had James Toller, PC Van Rensselaer, their co-defendants, and then people had, I believe it was on Zoom, and so it's fine, Mr. Toller is here. We were set for trial this week, and obviously that's not gonna happen. So I think we just need a new trial date.
All right, so, but you can't do the two cases together, right? So you have Mr. Toller.
I do.
All right. What now? No, I think that's Mr. Wilcutt's got Ms. Van Rensselaer. We'll do that one in a second. All right. So, I don't know, probably what we're going to need to do is set this, and then, because of the age of it, I don't have a problem at all and would probably rather set it at some time that I've already got something else set, because if I don't do that, it's going to be like May or June of next year. That's how far we've got things set out. And just give you a pre-trial a few weeks ahead of time and just try to see if one of those works out. And, because we've got a case in August that's been set 2 different times, and same kind of thing. It was right at it got canceled because somebody got sick, and then it got canceled because it was right at the cusp of when all this COVID started. And so I'm gonna, think that maybe it'll get worked out, but it might not. And I will set this with that, and we'll try to, that way we'll either get one or the other done. And that's August 12th and 13th, if you all are available for that. Yes.
What are they on?
No. There's one trial set that day. Yeah. So that is August 12th, 13th. And maybe we could do a pre-trial either at the end of, I don't care. You want to do August the 2nd? Because I think or is that too close? Would you rather do it the week before? Yeah. All right.
I know there's COVID, I'm assuming she has not been set for trial.
Correct. She's on here today, and I assume we'll be setting hers whenever I get to her case.
I just asked for, and I don't know where they are as far as any negotiations on that one, but obviously if there's any Julio evidence that comes forward, I would ask for that.
Yeah. All right. So, Mr. Toller, we're going to put you on for August the 12th, and it, very likely may go to the 13th as well. We'll do a pretrial on August the 2nd to, just to make sure we're still in line and ready to go. Okay. Be sure you stay in contact with your attorney. All right. All right. If you don't have any questions, you're free to go.
Your Honor, this is Kevin Crosland. I have Philip Massey on whenever you get a chance. I just want to let you know I'm here.
All right. Thank you. Is he, did I see? Yeah, he's on here. Okay. Yeah, y'all. Oh, yeah. Yeah, I'm sorry. I told Miss Gardner I'd do this one next. This Casey Van Rensselaer. That's Mr. Wilcutt, and she's on here too somewhere.
Yes.
There she is. All right. So are you all asking for that to be said as well? Am I wrong? All right.
That would be up to Mr. Wilco. We've had some discussions, but we've had some settlement negotiations, and he's never really asked for a trial date yet, so I don't know if this is something. we can
Okay.
resolve. If he thinks another pretrial would be.
Mr. Wilcutt, can you hear any of that?
I could hear some of it, Judge. In relationship to my client, and speaking of Ms. Gardner, I thought we were sort of kind of waiting to see what happened with the co-defendant's case as we progress forward. But without saying much more than that, I thought maybe we just might need to set her for an additional pretrial unless Ms. Gardner's ready to. And I'm happy to get into some further discussions with her. We just haven't got to that point thus far.
He's saying the same thing I'm saying.
Yeah, you all are saying the same.
Okay, I couldn't hear everything. So.
Yeah, you're saying essentially the same thing. Yeah.
And I'm happy to get a pretrial at the court's convenience out a little bit to see where we stand on this particular case.
Yeah, I mean, here's the thing. That other case we just set for August 12th and 13th. If we get to do it, then, you know, I guess it would make sense to maybe put this like the 23rd or something like that. We'll know one way or the other, I suppose. So August 23rd, how's that look for you?
That's fine, Judge.
All right. All right, Ms. Van Rensselaer, did you hear that?
Yes, August 23rd.
Yes, ma'am, 1 o'clock.
Okay, thank you.
Be sure you stay in contact with your attorney, all right?
I will.
All right, thank you.
Thank you, Judge.
All right. Ethan?
Yes, sir.
All right, you got his. Thank you. All right, Mr. Crosland, what say ye?
Yes, Your Honor. Mr. Massey and I had some trouble communicating as far as phone numbers and things for a little while there, but I've made contact with Mr. Massey. We've kind of got that straightened out. The Commonwealth has made an offer. I need to review that with Mr. Massey and see if we can't reach a resolution. So if I could get a little more time, I think next time we come back, we'll be able to either do a plea or set it for trial.
How long would suit you? I could probably do, let's see, 3 weeks. I could probably do June, either the 7th or 14th. Probably the 14th would probably be better.
I'm out of town one of those weeks. Is 14th on a Monday? Yes, it is. I can do the 14th. That's fine.
Okay. All right, good enough. 1 o'clock on the 14th.
Thank you, Your Honor.
So you and Mr. Massey don't need any information from one another. You've got that squared away?
That's correct.
All right. See you on the 14th. Okay, Ethan?
Okay, thank you.
Yep.
Thank
See
you.
you. What?
Judge, there's another case that was set for trial this week with 2 co-defendants, Brandy Anderson and her as well. So
Right.
these could be tried together. So we'll just need a trial date with both.
All right, Miss Anderson and Mr. Wells. They both here? Yeah. Yes, ma'am.
Some shifting around in our office, I have somehow ended up with 4 out of 6 co-defendants on this case.
There's
So
only 2
I-
co-defendants in this case.
I'm sorry, go ahead.
There's only 2 co-defendants in this case. It has to be another case. It's just these 2.
In any event,
Well, if you ended up with both of them, it'd still be the same problem,
Right,
probably.
yes.
Yeah.
Z has Miss Anderson.
Oh, Greg, I am too.
I was gonna ask the court for another pretrial conference day, just so that we can try to figure it out, and make sure that it's. And I apologize, I have to look at something else, but for some reason.
Yeah, no, that's fine.
I was gonna ask the court just for a little bit more time, so I can make sure that.
Well, I mean, I feel like you,
proper waivers if there has
yeah, I feel like you ought to get up to speed anyway. Yes,
I
ma'am.
completely understand that. What I would ask, this is an older case, and since we're setting trials out, I would like to go ahead and get a trial date, so it's on the calendar, because I've not received any indication ever that either of them are willing to settle. But I don't care to have another pretrial closer in time, so the office can figure out if there's any conflicts.
Yeah, I mean, I tell you, it's going to be out there pretty far when I,
I mean, if it's out there fairly far.
Yeah.
That's probably okay. I just didn't want to set something within the next 2 months and then look at it and, you know, have a knee reaction.
yeah. Oh, gosh. So I could probably, oh no, that ain't gonna work. You don't, I mean, this would take probably more than one day with two people. You think one day would do it?
So, yeah. I don't think I would have that many witnesses.
The reason I was going to say is I know I've got it, and the reason I haven't said anything on this day yet is because it's only one day and it's right in the middle of the week. It's Wednesday, the 10th of November. The next day is Veterans Day, so, you know, we couldn't have court if we, okay. They're gonna, are they gonna go through Veterans Day on that? Are they gonna have, are they gonna?
What's that now?
November the 11th is Veterans Day. That's a state holiday. Are y'all gonna skip that, or do you know? Yeah. It's the kind of thing that sneaks up on you. Like a lot of times you set these when it falls in the middle of the week, and like as the court, you forget that. So I didn't know if you all had talked about it.
A lot of times Hardin County will take, they take off on election hour anyway in the middle of the trial, so.
Yeah. Yeah. See, here's my big problem. I know y'all don't want to hear it, but I've got one trial that's set for the entire month of January and one trial two trials that are set for the entire month of February, 2 medical malpractice. All 3 of them are medical malpractice cases. Then I get over to March, got trials every week. I could still set it, but
Are you not setting any criminal trials then in the January, February?
I could set them, because I don't know if those cases are going to settle or not. Yeah. I would be setting them with other stuff, which we've done on a bunch of these other ones anyway. So, and the only reason I'm suspect is like one of them, my one that takes the whole month of January, it is a 13 CI 440 case. It's been set for trial. It was like a 3-year-old girl that the alleged malpractice occurred on. And every time we've gotten ready to try it, she's had to have another surgery. So you can't have it because she's not at maximum improvement or anything. We have to put it off. So, I mean, she's had a kidney taken out and artificial kidney or something put in. I don't remember what it was, transplant or something, a bunch of different things. So, I mean, who knows? We might get up there and they might say, oh, she's got another problem. So I don't mind setting it in January if y'all are okay with it, but I've just got a 8-year-old case that's set in front of it if everybody's cool with it. And I could do, that's set to start on January 12th and end on the 28th. So we could pick any of the days in there. I mean, if y'all just want to go ahead and do, or I could do it at the end of January you know, because I guess that trial theoretically could not take 3 weeks. If you thought maybe you wanted to try that, I could put it on January, 27th and 28th or something, which is a Thursday and Friday. And, maybe that other case wouldn't take the whole 3 weeks. They've just got, I think there's 12 expert witnesses in it.
Your Honor, I also have a motion on Mr. Wells.
Okay. All right. So, but what I can do is get us a pretrial kind of substantially before that, like sometime in the next 2 or 3 months, whatever you thought would be adequate there to give you enough time to talk to everybody. So let's say 1/27, 1/28, 2022. And then we could do a pretrial on want to do that in August, like say maybe August the 23rd. I just randomly chose that day. At 1 o'clock.
You say you're doing the pre-trial conference, the final pre-trial conference on August 3rd?
August 23rd. I mean, it wouldn't necessarily be our final one, but it would be, I could set one. Does that work for you? Okay. All right. So you all be sure to stay in contact with, and we'll Ms. Gardner, we'll talk about your motion too, but y'all be sure to stay in contact with Ms. Myers, because I think she might have to talk to you all, and then, there may be some changes in the way things work. And then let's see, when are you interested in doing that, Ms. Gardner? Yeah, I believe, that's true.
This is for failure to report for drug testing.
I believe that what his issue is going to be is that we got a report from the U-Turn people, or from pretrial, that he was on a pretrial drug testing and had failed to report for a drug test in April. I don't know that I've had any prior reports of that nature. I don't know who he was reporting to. Was he going to U-Turn, Amy?
Mr. Wells,
Correct.
he was going through Warren County. Is why he was still able to test.
Through Warren County?
Yes.
Like through pretrial over there?
Yes.
All right. What I'd like to do, maybe instead of putting him under arrest right here on the spot, would be to have him report over there and get a test today or tomorrow.
Okay, that would be fine.
When?
What?
2 days ago? He says they call you? Did they call you to come in? Okay. All right. Can they do one? Can they do one, Amy, can they call him and have him come in the next day or two? I don't know how they do it over there.
Yes, they should be able to. Let me get with someone in Warren County to make sure, but I don't think that would be a problem.
Well, I mean, because he's been out on bond for a year and a half, and this is the first time I've gotten a report like that. So, I mean, I would like to try to give him a chance to show me that was an anomaly.
Right. We have trouble keeping up with him as far as call-ins. If I could get a current number for him. And I'll
tell me your-
update them as well.
270
Okay.
535 0736.
0736. Okay. And I'll get with Warren County pretrial and see if we can't get him taken care of.
All right.
I'll shoot him an email right now.
Like he said, they're doing his drug screens.
Yeah. This is what I'm going to do for now because I don't want him to be walking in over there and getting arrested. I'm going to recall this warrant, but I want you to let me know in a couple days, Amy, if you don't care how that turned out, you know, that he showed up and that they called him, that he came in and that he was clean. All three of those things are the way I'm hoping they'll go.
Okay. Yes,
Call me.
sir. Will do.
All right. Yeah, super. All right, Mr. Wells, be on the lookout for a phone call. All right, thank you.
Just what is his return date?
Oh, shoot. August 23rd.
Okay, thank you.
I don't know what's happened down there in district court, but the jail still hasn't got on there yet. Not that we've been in a big hurry or anything. Oh, Lord. How you doing?
Judge, in this case, we don't have a resolution. Greg has given a counter offer. I've discussed that counter offer with the representative of the cabinet, also with the case officer in the case. At this point, the Commonwealth is not agreeing with that counter offer. We're either going to need to set a trial date today or maybe do a more pre-trial conference. See if there's any further negotiations after that.
Yeah, y'all tell me. I'll do either one.
At this point, only would be, so you and I talk more, Greg, mediate, set the trial.
Yeah, I guess we can give it one more shot.
So you're wondering, I mean, you mentioned mediation. Is that something you all have ever talked about, or do you want to talk to Greg about that whenever you? Yeah. Oh, I mean, you all can just, if you're going to talk about it.
Yeah, we can talk about these things.
All right. They're, the chief is strongly encouraging us to get people, just because we're so far, I mean, the trials were so far behind. Not that everybody doesn't understand, because you do understand. So, all right. So, I guess you want to look at that. I mean, before you know it here, we're going to be talking about this July date anyway. You want to just talk about July 5th? I mean, 12th? Yeah. If you all did talk about the mediation question and agreed to it, don't have to wait till July 12th to tell me. You just tell me and I can send it in. All right, Mr. Berry, does that work? All right, thank you. Huh? There is a request on the table for a short break, so I think that's what we'll do. We'll be right back. Hang in there, everybody. so she can't hear me. I think she might be in like a sober living house or something. Tiffany Court.
Yes, sir.
Hey, how are you?
Good.
Mr. Berry, your attorney was telling us that he wasn't sure he had the right number for you or something, because he said he called and there wasn't like a voicemail or anything, so he hadn't been able to talk to you. Do you have
Yeah.
a phone, or what am I missing?
It's a house phone here at the place that I'm at. It's
Okay.
270-683-7007.
Is there a certain time where he might be able to call and get somebody to answer?
Oh, they're supposed to answer it every time they call. It's part of the rules here, but I mean, he can call anytime. I should be able to be on the phone.
What's the name of it there where you are?
Friends of Sinners.
Say again?
Friends of Sinners.
Friends of Sinners. I got you. Yeah. So that's like a sober living?
Kinda, yeah. It's like you do Celebrate Recovery, and like you go to church and you work a job and all that.
Okay. Well, I got you. So I don't know. I mean, she seems to think that there's somebody kind of hovering around in the general area of the phone most of the time. So I don't know if it was just bad timing.
Let me make sure it's the right phone number. Can I go ask the house mom real quick?
Oh, heck yeah.
Okay. Hey, what's the phone number here? It's 683-7007.
That might answer our question.
What's Tammy's number? All right, yeah, that's the house number. I'm gonna ask if I can give you the house mom's cell phone number too.
Oh, yes.
Okay. Okay. What is Tammy's number? All right. Her name's Tammy. And she's she's here every day from like 9 to 4.
Okay.
So her phone number is 222-9523. And then also the house phone number too, as well, is 683-7007.
Got both those? All right. All right. So listen, he's got obviously some things he needs to talk with you about before we can decide how to go forward. So we're going to put it off 3 or 4 weeks or something like that to give y'all time to talk. Let's look at, I know I said I wasn't going to do it anymore, but let's look at June the 7th, Greg. You want to do that? Yeah, Monday, June 7th. Well, if I don't do that, it's going to be July the whatever. No, I guess I can do June 28th. That's a date that Mike's going to be here. I forgot. All right, Miss Court. So we'll try to do June 28th at 1 o'clock again. Okay.
Okay.
All right. Thank you.
I'm sorry. What is my lawyer's name? Mr. Berry?
Yes. Berry.
Okay. All right. Thank you.
Thank you. Okay.
Charles Childress.
Thank you. All right. Yes, sir.
We talked about getting a pre-trial conference in this case. Discovery's out, offer's out.
and they just talked to Fund about it.
That's correct, Your Honor. We had the discovery, we had the offer. I wanted to go over the offer a little bit more in depth as far as collateral consequences of accepting the offer with Mr. Childress. Two things to think about the offer too. I was gonna ask the court to give us another pretrial conference on it and see if we can resolve the case.
Yeah, that's fine. What do you, seriously? What do you have in mind?
I know 2 weeks might be a little bit, if you get the court can go out 3. I think that's probably.
All right, Jennifer, don't get mad at me. We can do June the 7th. I will take fully 25% of the responsibility for how busy that day is. The rest of it's your fault. All right, thank you. She didn't know what you're talking about. She thinks you're actually blaming her for something.
She doesn't yet, but when we're here at midnight, she might.
We've got,
It's crazy, the first of June.
the first 2 Mondays in June, we've just got a million things, but I mean, we got to do them. So might as well do them. There's no way. Yeah. Well, you know, this whole first month or so back with people able to come in and all that have all been basically just, you know, let's all meet each other again and then put them off, you know. So all of those that have come in the last month have been moved off a month. So that's where we are. But anyway, I think I've got the Barron County Detention Center on here now. Let's wake him up. Wake that guy up over there. We've got, yeah. Hey, listen, I don't blame you one bit. I'm going to ask him to install me a treadmill in our new place. Only just get me a, could you imagine? I'd get in all kind of shape up here. All right. Who do you want to call, Mr. Price? Well, choose one at random or otherwise. Oh, yeah. Yeah, that, do you have Miss Cords? Bonnie? She had done me the solid of muting it.
Hello, Judge.
Get up. All right. All right, Miss Cords. I have Mr. Price here. How are you?
Hurting. My knee is killing me.
You're what?
My knee is hurting very bad today.
I understand. What do you all have in mind here?
We've actually got office conference scheduled for Thursday. We have been discussions, and I think hopefully we'll move those discussions along on Thursday. Can we come back on Monday, or is that?
We got to do it sometime. So if you want to do it Monday, we'll do it Monday. I mean, all the Mondays for the foreseeable future are going
Is that okay with you?
Yeah, because I'm going to be here next Monday.
Okay. I see that you, which I didn't catch this the first time around, but I see that you had a motion for a bill of particulars.
Your Honor, I was going to address that.
Yeah.
We addressed that on the arraignment, and I said that would be filed. That was filed the same day. I spoke to the prosecutor, and I completely understand the fact that there's 1,000 pictures. I'm going to charge you with 20 of them because that's the maximum I can do. But I still need to know exactly which one of these pictures we're going to be trying, because her connection to this charge is based on a statute that relates back to using a weapon. So she's not going to be responsible for all pictures. It's going to be a very select few of those pictures. That's exactly what I'm talking about.
Okay.
So I'm gonna meet with the prosecutor on Thursday. Another issue is we finally got back the phone dumps that we were discussing. And I think it all together, it's just about 200 gigs of information. So I brought a flash drive today that isn't even close to big enough. I don't even know if I'm gonna be able to find it. And to sort through that information is gonna be arduous to say the least. So
Right.
if we can get to a point on Thursday that we're close to resolution, that'd be nice. But there's no way I'm gonna have all this discovery to you, Danielle, or be able to even look through them. Another issue that's still before the court is the issue of bond. I haven't gotten a written decision on that.
You're right.
And this is something that she has severe health issues stemming from a car accident, which is in discovery, Your Honor. It's well known to everybody that she has these complications. It's well known that she needed medical treatment. It's well known that she's on disability, her status. Right now, she's actually out of contacts, doesn't have her glasses. All this stuff is still at the home where she has here. She has a storage facility in town that is going to be up probably, I think it was up last week. So she's in need of losing all her things. And again, this is somebody, the alleged victim lives, I want to say 1,500 miles away, no longer in state, no possibility of contact. Is she still in state? Okay. My understanding was that Children's Protective Services had moved her out of state, but she's from North Dakota. It's very easy to make sure she has no contact, stay separated. I don't even think she has a cell phone anymore because in the position of the state, so I don't know if she'd be able to even call anybody. So with certain restrictions, she can absolutely be trusted in the community. I think it would lend itself to resolving this matter because I would be able to meet with her and discuss this, especially with just an obscene amount of discovery coming on Thursday.
Yeah, I can imagine that you're going to get a bunch. I knew that you had filed that motion, the bill of particulars motion. Generally, in previous cases, because we enter a discovery order, an arraignment order, the Commonwealth, and it isn't always the case, but I mean, most of the time, you all have argued that you provide open file discovery, and there's some case law that says if you do that, and you make everything available to them. I understand that in a case like this, if you've got, whatever, 5,000 pictures and 20 charges, you kind of have to narrow that down. Do I understand you to say that that you expect to get that narrowed down on Thursday? And if you don't, you're going to tell me, or?
And this has been my history. In this situation, they say your number is 20 because that's the maximum. So it could be any 20 at any time. And so when you get to trial, they say, okay, we're just going to do these 20. But in this circumstance, Your Honor, if I had taken those pictures and I was being prosecuted like Mr. Mann was being prosecuted for having those pictures and taking those pictures. With Ms. Cordes, she's being prosecuted, and this is just my belief in speaking to the prosecutor, under the abuse, neglect, dependency, which means she had a duty to report knowing about the pictures. And that's going to be a distinct subset of these pictures. So that's what we're looking at.
Okay.
Discovery, Ms. Cordes did interviews with the Grand County Sheriff's Department. And in those interviews, she admitted knowing about the child pornography that was on these devices that Mr. Mann had. And she is charged with complicity for not knowing about it, not doing anything about it. It was in her possession. And they lived in a small room over on Munch Avenue, an attic facility. She had very easy access to those items and knew what was there, what was on those devices. We have charged Mr. Mann for possession of it, her complicity of it, for her knowledge and failure to act on that. And we intend at trial to offer images, if we have to show what they are. They are on a hard drive that's over at the Grand County Sheriff's Office. Obviously, I can provide those in discovery, physical copies of those.
Right. I mean, yeah.
The ability to access those needs to, but those are on. They were dumped on from ROCIC Nashville. So that device, images are at the Grand County Sheriff's Office in their custody. We'll make that available and have access to it. And obviously, at trial, we will have to identify which images we are going to rely on. But at this point, there's hundreds, if not thousands, of images on those devices. And so that's the Commonwealth position is that we do practice under file discovery. We'll provide him access to those. He can go view those images at any time. You know, prior to trial, we'll identify these are the specific pictures that we're talking about. And go from there.
Well, I guess my question to you is, what if I order them to, I mean, they're already under an obligation to provide, I guess what I'm trying to figure out is what, I could understand if the motion was, you know, I want a date certain by which they identify what 9 pictures or however many counts there are. Yeah. Well, but there's only 7 counts, right? Or 6 counts of complicity. So there would be 6 explicit, or I shouldn't say that, 6 specific pictures that they would have to identify, right? And I certainly think that if we set this for trial, it would be reasonable to say there has to be a drop dead date that you identify those 6 pictures within the realm of all the pictures that you have given you guys access to. I don't know how to decide when to tell them to do that at this early, you know, it's kind of an early stage because we don't have a trial date set.
And Your Honor, if I could, I don't mean to be rude, but
No, you're not
last
being
time we were
rude.
here, we discussed the trial date, we discussed bringing it forward this amount, because it's not gonna really change when we would set that trial date, so I would be asking for a trial date today. So, I know we're gonna discuss this, but this needs to be something that's moving along. So I'd ask for that number and those pictures relatively soon. And it would also say the sheriff's department and myself scheduling what could be hours when we sit with the sheriff's deputy staring at these pictures.
Yeah,
So it goes on 2 levels.
I understand. Well, would it,
We'll gladly go through and take the worst ones and say,
well, and I was getting ready to say, surely there is some sort of gradation of, I mean, you know, you're gonna,
there's a plethora of
Yeah.
images that we can choose in this situation. It's not going to be a problem choosing
Yeah.
which 6 that we're going to.
And there's usually, and I don't mean to be facetious about this, but there's some contenders, I'm sure the Commonwealth knows that, this is gonna be the picture, so.
oh, I'm sure.
Actually, I'm not reviewing this one. I just know with the aggravation.
Yeah, I understand. Well, why don't I do this? Why don't, I mean, it's not going to make any difference as far as what day I set if I do it today or Monday. So why don't I let you all meet? You may or may not have things whittled down in some better fashion. If you don't, that's fine. Come back on Monday and we'll talk about, I agree that you are entitled to get those identified at some point. And I agree that if you want to set a trial date, you're entitled to do that too. So I'll set it on Monday if you all tell me to. And then we'll, depending on what we can come up with for that, I'll give you a certain drop dead date that those things have to be identified and kind of winnowed out from the herd so that you know exactly what it is that you're dealing with. Okay? Are you all planning, I mean, do you anticipate that these, I don't know enough about it to know whether you anticipate that these will be tried at the same time or at 2 different times? Okay. Okay. And I guess the other question would be, would you anticipate that in that context, you would be doing one of them before the other one specifically, and which one, this one or the other one? Because that will inform when I set the trial. I mean, you know, you get into a lot of issues that I don't want to worry about later. I want to worry about them now. Like, do you use the same jury panel? Do I have to figure out when one group's going off and the other one's going on so that I set it in front of 2 different jury panels and that kind of thing?
In my experience, when you have something of this nature, it can be very traumatizing. So I've usually had 2 panels called in just to make sure to get one jury, because you have people that can absolutely not do that.
Oh yeah, you're going to have a hard time getting a jury anytime you.
Even use the same panel, it's going to be, you're going to have everybody start getting excused.
Yeah, yeah.
I would say probably not.
I'll have to figure out, remind me, because I mean, we'll know how far we're doing things different than we used to do just because we're calling them in for but we used to only call them in for 2 months at a time because when you're trying a lot of cases, you don't want to overtax them. So, I may have to find a line of demarcation in there. And we are calling more jurors than normal because so many people, you can get, I hate to put it that way, but you can get out of it a lot easier now. You can just say, I don't feel comfortable going out in the world and I have to excuse you. So, all right. Well, that's an overstatement, but you know what I mean. All right. So, we'll just get back on Monday and Ms. Cords, your attorney and the Commonwealth are going to meet. And then I'm going to, we'll do what we need to do. Whatever they tell me is still on the table that needs to be done when I see them again in a week. That's what we'll do.
Okay, now I still have an issue about the storage unit. We're going to lose everything, Your Honor. It was due last Monday. Is there any way that I can get that 48-hour furlough so that I can take care of the storage unit so I don't lose everything?
Yeah, let me tell you, where is the
Budget storage.
young person? Yeah, I don't mean specifically, but I mean.
She is, I think she's.
Oh, you do think she is? Okay.
Even if she was right next door, sir, I have honestly no way. I
know.
don't want to discuss
I know.
that.
I know you don't want to, but is there any way that you could just find out a general area of where she is? And if you were to be out, where would you be going?
I'd go right back to the house that I was arrested at.
Give me that address.
The 302 Bunch Avenue.
All right, so it's just right here within
Yes,
a mile of where we are right now.
yes, sir.
Yeah, all right. So
I have no issues going to court, or I have no issues doing anything.
I understand. If you can find out in the next day or so where she is so that I can at least factor that into what I'm gonna. All right. Ms. Cords, I don't blame you a bit if you don't like this answer, but I need to find out a couple more things from the Commonwealth about where this person is and so that I can feel comfortable about how, if we're going to do anything, how we're going to do it. Okay. So, I'll just, I'll let you know something. I know I'm going to see you next week. I'll try to do something before then. I promise. But,
is there any way that,
I'll see you on Monday.
is there any way that I can at least get my phone so that I can call storage and pay storage this week? I don't care I don't care if it's me giving my current.
Hold on for a second.
Yeah, hold on.
Part of the issue is that she gets disability on her. She has this money available to her, but her card that she gets the disability put on is back in the house. So even if she had like a 24-hour furlough, she could resolve a lot of things just by getting the items out of that house.
Yeah, I understand. Listen, and I'm not holding this against Ms. Cords. I don't know what it is, but some kind of wave has gone through the jail down there, and I've furloughed. I've had no luck before. I've let people out on furloughs since the beginning of the year, and about 75% of them have just run off. And it's not her fault.
I'm not one of those. I was in the same house. No, I was in the
single one of them sat there and said, "I'd be a fool to run off, Judge," and then they all ran off. So,
I was literally in the same home that they arrested my husband at for the entire time that he was in jail. If I was going to run, I would have ran at that point in time.
I understand.
I'm not going to run. My main concern is making sure I don't lose my stuff.
I understand. I promise.
And I've tried making the phone calls. No one's answering.
All right. Listen, there's a lot. There's more than one angle I got to look at this from. Okay. I'm not trying to put you off, but that's where we are. I'll try to get something done before I talk to you again. Okay.
Neil, I'm going to see you Thursday after I talk to the prosecutor.
All right.
Your Honor, do you want to call Mr. Mann?
Yeah, we can. All right, Ms. Cords. Thank you. Mr. Manth. because I'll have to project that out, you know. All right, yes, ma'am. Where are we?
We divided Discovery in this, lead that, sent off of man. You haven't got that. I'll check on that. That's,
I mean, it's possible that maybe it's the office not uploaded to me just yet, but I don't think I got the supplemental discovery.
supplemental Discovery was phoned up.
Just put it over on the left.
It's back, we have it now. I'll double check. and see if
Okay, so what are you all going to ask me to do here today?
Judge, I'll be fine with one more pre-trial conference, so I can get an offer to her and then start that process if we can.
But you don't necessarily want it as, at the same time as that
No,
other
no,
one?
not that.
All right,
I would say probably now. Okay with that.
that's going to be, don't throw it at me, June 14th.
Oh, well, we need to go. I'm fine with going. We need to lighten the load.
Well, here's the issue that I've got. If we get over into July, there's a bunch of time you're going in July. Right.
I'm going 28th of June.
Yeah. So we have judicial college the week of the 21st of June. So that's out. 28th will be out. 5th is a holiday. 12th is out. 19th is out. 26th, you're just coming back. So you probably hadn't had time to do anything unless you tell me I'm wrong, which won't hurt my feelings. So, I mean, because you're going to be going from the 11th to the 23rd or something. Isn't that what you said? July 26th. Okay. All right. So that's what we shall do. Thank you. Let's see. Well, we'll just have to wing it. All right. All right, Mr. Manth. Your attorney's waiting on some things and she's going to get those things and then she'll be in touch with you. Okay.
Yes, sir.
All right. All right, Ms. Gardner.
Judge, who we call Carrie Kennedy?
Carrie Kennedy. Thank you.
Judge, she was originally set for trial this week. He's not set for trial yet. He's set for pre-trial on June the 7th. I'd like to have her set for that.
Okay, where is the, I don't even remember. It's been a minute, so I don't remember who that is. I'm trying to. Okay. Who represents him? All right. So that's 6, 7, 1 o'clock. Okay. All right, just be sure that you all are, that you stay in contact with your attorney, okay? All right, thank you. Thank you.
Price, Timothy Miller, Mr. Price, and I have had conversations about resolving this case. I emailed him all today, and we'll meet on Thursday. Go back.
We can come back up next Monday, Your Honor.
As in a week from today?
Yeah.
Okay.
We're gonna be here anyway. And Your Honor, there was another time you're here for Mr. Miller. We discussed his bond, not to be overly rehashing. Your Honor revoked his bond based on positive drug tests. I was actually resident who met with him because he was so furious over the video. Whenever I talked to him, he actually was very calm, very apologetic. He actually apologized to me for his behavior. I told him that's a conversation he needs to have with you, but he said he told me that he had been with a U-turn. They sent him to Morgantown for 30 days. He did 30 days, Your Honor. He had concerns about being around his mother, so he wanted to come back local.
Can I get him up here? He's not up here yet.
You are kidding me.
No.
That was amazing.
Timothy Miller. That was some silver tongue deviltry right there. We'll have to get you back on.
I can't see anybody. I just assume.
Yeah. Can you not see?
No, it's you.
Yeah, that's not supposed to be happening. I wouldn't force that on anybody.
It's you and a couple people on the phone.
Standing up there now.
All right.
Is that him in the middle? Yeah.
Mr. Miller, can you hear me?
Yes, sir.
All right. Is that working now?
No, down switch. Yes, okay. He's on the big part.
All right. I think maybe if I take it off of, if I put it on gallery view, then it shows whoever's talking. So it's the opposite of what I normally do, because normally I put it on speaker view so that I can record the speaker. So, but anyway. All right, Mr. Miller,
Yes, sir.
your attorney was just getting ready to tell me some things about his conversation with you.
Yes, sir.
I was telling him about our conversation we had about how you're apologetic with me and that I advised you to inform the court about that, but also that you had finished a U-turn 30-day program out of Morgantown, and when you moved back here, you started to select. And Your Honor, whenever I was talking to him, he actually admitted that he's an addict and he needs help. I don't know if that's ever been something he's done before, but that's short-lived from what I know. Whenever I was talking to him, he was sincere in the fact that this was the first time that he admitted he's an addict and that he needs help. He would like to go back and do something, but he would like it to be local so it can be around his grandmother and mother. Okay? Whenever you're dealing with this, whenever you're dealing with addiction is the hardest part, but he also needs a support system. Whenever he went to Morgantown, he was successful, but it was just too far from home. So whenever he tested positive, I think he's been in 4 months just on that 30 test, Your Honor. So if we can release him and maybe do something U-turn, I think he had a life skills IOP lined up here. I'm not positive about that, but I think that's where.
I don't know, Mr. Miller, did you have something? Was Julie helping you get in somewhere or start some intensive outpatient or something?
Yes, sir. I'd already actually started doing visits with one-on-one therapists through Zoom, through the life skills. And I'd already made one meeting and had scheduled for the next one.
Okay.
And I was going to U-turn and to life skills and seeing a therapist. If I could, I'd like to continue that.
I understand.
Yeah.
All right. All right, hold on a sec. Mr. Gardner, what do you have to say, if anything?
Judge, like I said, I've given a great offer. I think it's a reasonable offer. And I think it'll probably resolve the case. We're right at the end here. And if we don't have a resolution, I think this will probably will make it Monday. But this close to it, or Greg knows where he is. If he would talk to me and possibly get this case resolved, I would prefer that let me be done until Monday. If we don't have a resolution, we do it on Monday.
I guess the merit of that, to the extent that there is any, is that there is a reasonable prospect of you getting this thing resolved. Nothing untoward can happen between now and Monday if he stays in custody. I honestly don't. I mean, I do think that he's been in there a substantial amount of time. He's been unable to make. He does have a cash bond that he hadn't been able to make. That he was on an unsecured bond before all the problems happened, and I changed it to a cash bond. So, Mr. Miller, let me tell you this. All right.
Yeah.
And I know this sounds like that I'm putting you off, and I'm not. But I do think that since your attorney is going to be coming back into town and meeting with the Commonwealth, and I think he'll have the chance to meet with you, I'm going to put you on for Monday. It's just a week from today. If you all don't get your case resolved, we'll put you back on for Monday. I plan on changing your bond in some way, if that's necessary. And for that matter, that's you can bring it up regardless of how the case turns out, but regardless of whether you all have any kind of agreement. I'm not telling you that you can't, but I'd like to kind of the way Mr. Gardner put it. I agree with if you're this close to the finish line, maybe let's just stick it out one more week and see if I'll know where you are, he'll know where you are. You can't really get into anything, and maybe you all can get it resolved. If you can't, then we can revisit your bond question. And I am going to be receptive to what you're asking for. I don't know exactly what form it'll take, but you've been in there long enough that if you're ever going to learn anything, as on a bond situation,
Yeah.
I feel like you've learned what you can learn, and I'd be able to trust you to be able to move forward with the case and not have any more problems.
You could.
All right.
Yeah, and if I could, I'd like to apologize for I should have been listening when I was talking to 2 days ago. I apologize.
Apology accepted.
Okay, thank you.
All right. I'll see you on Monday, okay?
All right, thank you.
I'll see you on Thursday. Yes.
You sounded excited about this one. Let's see. You have Mr. Tucker? Is that what you said? There he is. Okay. Hidden on my. Oh, yeah, he is. All right.
I think Mr. Price was, conflict counsel for DPA. I think we've already seen discovery in this case. So that's all discussion.
Mr. Tucker, to that end, did you get the discovery I left at the jail?
No,
You haven't got discovery?
no.
Well, sir, I apologize. That's completely my responsibility. You're gonna have that today before I leave town, and then I'm gonna see you Thursday with discovery and the offer, okay?
Okay.
You're going to drop it by there and today before he leaves. And then he's going to be back on Thursday. He's going to make an appointment and get up there and see you.
Okay.
I just wasn't sure if you could hear everything he was saying because the sound's not the greatest. So I was just repeating what he said. Okay.
Yeah.
All right. We'll do Monday. Okay. Yeah. Did we ever figure out what's?
Your Honor, I had an arraignment set last Thursday. That made a 5-day trial, and I did not have that arraignment, so I didn't get to have it.
Oh.
I'm still just as good.
She's encoded them in a JSON Smith, which is my understanding. So they would be getting a trial date in that one today. I don't believe that these could be tried together, but it's tried.
Yeah. Tanisha Shirley. Yes.
Not to speak out of turn, but I was
I mean, I'm not opposed to settling her case, but we haven't, we're not reaching an agreement yet. Who was that?
Yeah. As far as you know, she has a trial.
The problem is, she had a trial set, they canceled the trial, and never said anything else. So if you look at that case right now, there's nothing set.
Oh, there's no future court date.
I don't think they're having guest meeting last week and.
So what are they doing over
they're
there,
just
officer?
doing it in custody. They're just doing it in
People in
custody.
custody, they're not doing anything else.
Yeah.
Well, she's in custody.
She's in custody.
Right, but I don't think they're having trials.
Oh, yeah, I understand that.
But she's not doing it for a free-
But I mean, yeah, does she not, do you think she's not got any kind of pretrial or anything like that scheduled at all?
At least not that's been published. on.
Yeah.
And that's really been governing where we've been going, but at a certain point, we just need to take it.
Yeah, I don't know that this necessarily would interfere. I haven't had any discussions with Justice Stockton about this case. It says an arraignment is scheduled for June 17, 2021.
That's her Cox charge. I think the Cox charge is what.
What got everything?
Yes.
The other one on that same date.
See where it's all coming together?
That's where you're assuming facts, not in evidence.
So I don't know if you want to set this for trial.
That's fine, set it up month. You want to put it in July or month. We're not gonna know anything June 14th. I'm gone. You're gone 21st. I'm on the 28th. So the 12th.
Yeah,
July 12th.
July 12th would probably be. I have to think that as soon as, I mean, we're going to get word this week from the, powers that be about the new rules and things are going to open up a little bit.
Well, they said the governor is opening all venues.
Well, but the governor doesn't,
Rest of June 11th.
yeah, but he isn't in charge of our venues on account of that whole separation of powers deal.
Hey, Your Honor, while we got here, I don't want to get the same quagmire. Can we just set a trial date for her? And if need be, we can move it.
I mean, we can. I don't know when, I don't know. Well, what's hard to do is if they want to set that other one first. And no, I'm sure he's there. Yeah, I'm sure he's stage left where I can't see him. Yeah, he's on today. Yeah, it's fine. Miss Shirley, can you have a seat and we're gonna get Mr. Smith up here first. Yeah, I already have him. All right, so you're, time out. What did I say? I didn't write it down.
This is Charles Wells, Randy Anderson. July 27th and 28th.
All right. So, I mean, we're kind of in the same boat with this one if we're going to set it for trial as we were with that other one, which is I can set it like in January and, just hope that that other civil case that I've got works. I can do it the week before that Wells and Anderson thing. Be hard to get it in January and do it after that since it was the last two Thursday and Friday of January. I could do the week before this one, like the 20th, if you think 2 days, 21st, 18th and 19th, which is a Tuesday and a Wednesday. I mean, any of those are fine. What do you think? Thursday and Friday. All right. 20 CR 418 Jason Smith. Now, and I guess I'm gonna Mr. Price, I'm going to say this for your benefit too, because what we were talking about was his defendant setting this one first, so that then I could set his. Well, what if we don't get to do this one because the other trial doesn't continue, but then I set his a week, a month later, and we do get to do it? Okay, all right. I just wanted to bring it up ahead of time rather than waiting and having everybody fight about it at the time. All right. Okay, so let's get him on for a pretrial. If we're going to do January the 20th, I mean, you want to do a pretrial on the, let's see, what will the holiday be? The 3rd, Monday the 3rd will be a holiday because the way the state does the holidays, it's New Year's Eve and New Year's Day, and it's the first weekday if it's on a weekend. New Year's Eve's a Friday, so that'll be a holiday. New Year's Day is a Saturday. The 2nd is a Sunday, so we'll get a holiday on the 3rd. So we could put a pretrial on the 10th of January. All right, so that's January 20th and 21st for our trial. Pretrial January 10th at 1 o'clock. Okay? Work. All right. Thank you. All right, now we'll talk to Miss Shirley now. Do you want to do, I don't know how your schedule, you want to look at, again, in February, I've got the first 3 weeks of February, I've got this malpractice case. But the last 2 days of that trial are like the 17th and the 18th of February. So I could set this on the 17th and the 18th because that one could end up getting done earlier, or, any of a variety of things could conceivably happen. Yeah. Well, and anytime that we're normally looking at something that might be one long day, I'm just kind of thinking if we're still having any distancing issues and all that stuff, it might take a little longer. Well, I wasn't real sure 15 months ago that we'd still be doing it 15 months from then. Yeah. Yeah. So. Yeah. February 17th and 18th will be 20 CR 40.
Your Honor, and I've spoken to Ms. Shirley about this as well. I've been relying on that other case being resolved, so we'll know exactly where we need to go, since that's been languishing. We're gonna have to start working on it. We'll get our side vision, whether or not.
Understood. Ms. Shirley, we're gonna put your trial date down. I mean, it's just necessarily, it's far off into the distance, but it's gonna be in February 17 and 18. We'll give you a pretrial earlier in the month of February, and your attorney will be talking to you, okay?
Okay, thank you.
All right, thank you. See you later. Michael Johnson? I don't see him unless he's this telephone. Michael Johnson? No, I got nothing. Yes. Well, the thing is, he would have been here when I set these, because we were meeting in person. I wouldn't have set a trial if he wasn't here to hear it. So, this is his pretrial and he's not here. So I'm going to issue a bench warrant. None of his dates have been rescheduled or anything.
Johnson that you had similar charges. I thought that person was on.
I don't remember.
It's been a long time since.
Yeah, I mean, he wasn't in here. He was in here in September. That's the last time we saw him. All right. Well, that's all we can do for now.
Some of the Commonwealth would probably consider our course.
Yeah, I mean, I don't know how, I mean, we've got 10 or 12 cases set for trial. I don't know that y'all gonna get geared up for one that the guy's out in the wind and has a warrant out on him. We probably need to look at somebody that's here. I said a bunch of them, but remember we talked about it because I wanted to be able to, I mean, this was back in the summer and of course everybody was wanting trial dates. And so we just stacked them up saying that we'll try something, hopefully. All right. Listen, I've still got Hart County on here. They got 2 people. Can I do them real quick? Yeah. Can we get Mr. Coy first? They're ready to talk about him first. Thank you. Yes, sir.
Say that should never medical record should be in there, right? Okay. That's something that's missing.
All right. Well, do you want to look at that June 28th day just to give you time to track it down and see if you've got stuff you need to give them and then get it to them? All right. We'll do that pretrial June 28th, 1 o'clock. If they don't ever talk, they don't pop up on the, yeah. All right, Mr. Page.
$462.
All right. This is Mr. Page. Mr. Bell,
Yes, Your Honor.
you hear me? Okay.
I do.
All right. What do we have? Anything?
No, we've had an offer on Mr. Page for a short bit of time. I've discussed that with him. However, he's not got his case over in Hart County resolved. He's got another attorney over there.
difficult to resolve this over here until we know what's gonna happen over there. And, but I know it's time starting to draw in on us, Judge, so I guess if the court could give us one more pretrial, if we can't get anything resolved, we'll just have to set a trial date or do what we need to do. I don't know anything else.
What's the case in Hart County?
Well, I have a bond hearing, I think it might be tomorrow or next week or sometimes. I'm finally having my bond hearing over here. I'm still on a $25,000 cash bond over here. Same thing's been for the whole 5 months I've been here.
Okay.
I can't think of the charges right off the top of my head, Judge. I can look them up right quick if you want me to, but.
All right.
He does have a free trial tomorrow, according to court then.
All right. So when do you want to, well, Ms. Gardner, do you want to, I guess just as long as we get it out past, you want to do June well, I mean, we can do the 7th or the 14th. I mean, or we can go over into July, either one.
June 7th or 14th is fine with me.
Does that work for you, Johnny?
I've got a lot on the 14th. I would prefer July, but it's whatever makes everybody happy, Judge.
Do you care if we, all right. We can do July the 12th.
Thank you, Judge.
All right.
I've got two more, Judge. You want to finish the jail up?
That gets our friends in Mumfordville, so I can let them go.
Thank you, Your Honor.
Thank you.
He has James Alexander.
Right.
We need to get a trial date for him.
Ed James is on Zoom, Your Honor.
Yeah. All right. Go ahead, Ms. Gardner.
Johnny, has he rejected that last offer that I made?
I have not been able to speak to James about that. If we could, if you're going to give us a pre-trial in 2 weeks, Judge, go ahead and set the trial date too if you want. But I would like to relay that offer to James and make sure that he wants to see what he wants to do in that circumstance.
He said he wants to talk to him about it, so.
I can't hardly hear anything you're saying, Johnny. It's cutting in and out somehow. But if I understood you correctly, you were saying that you would like to have a little bit of time to go over this new offer. I can't do 2 weeks because that's Memorial Day, but I can do 3 weeks.
That's fine, Judge.
Love you, Brian.
Which is June 7th.
That's fine, Judge.
All right.
The last case I've got is Melissa York here on.
Is she with you?
She is, Judge. Come around here so they can see you. Where's she? There she is, Judge, present and accounted for.
All right.
Judge, if we can put her on June the 7th, we've got an offer on her case also. We'll review that. If we can accept it or we'll set a trial on the 7th if it pleases the court.
All right, deal.
Thank you, Judge. Y'all have a good day.
Too late.
I getting ready to say it's too late for everybody. I agree.
The have a good day ship sailed.
Yes, it has, Chuck.
Yeah.
Thank
See ya.
you.
Who? Michael Riley? All right. Yes, sir.
Judge Rivera, I thought that was, I made a remark on that case. It's just a matter of, it's a kid discussing that.
All right. Reckon we can do June the 28th. I guess that will give you some time, wouldn't it? Mr. Berry? Yeah. Go ahead.
Pending felony charge, Warren County, and if I remember correctly, he also, I don't think his record here in Kentucky is, that's just Kentucky, I believe. Also, I discussed this with Mr. Burke as well, that he has some charges out of Nashville, or at least in Tennessee, that were similar to the charges that he has here, if I remember right. I'm not prepared to argue a bond motion, so I don't have all that in front of me, but that would be my concern as far as the bond being.
Well, I think I was under the impression when this case started, at least, that there was another warrant out of Warren County. I don't know if that was wrong or if that's been resolved, but at least when he got indicted, that was what I think that's what the record was indicating. But I don't remember. I'd have to go back and look. I don't really remember.
I would say based on the court ruling. I'm not prepared to argue a bond motion as far as today. I'm just going to go off the top of my head. But I know that this record here is not a true reflection of propensity to commit other crimes. That's all we said. I think $5,000 cash is probably appropriate.
Okay. Mr. Berry, I'll take a look at it, and what I'll do is I'll see if there's any information from pretrial that might help me. I mean, I don't know if the bond was largely due to or at least certainly in part due to the out-of-state thing, but I know it was also due to, there were apparently several warrants pending, at least, maybe not several, it kind of depends on how you define several, but more than one when all this happened. If that's how I remember it, and that could be wrong, I'll just need to look and see what we've got. Let's put it on for 6/28, and I'll look at it between now and then, and I'll see what's on the record, and I may do something with it. All right.
Also got Leon Trulaw.
Leon Trulock. All right. Mr. Trulock, yeah, there he is. All right, folks. What were you doing? I'm just kidding. Yeah, I'm just kidding. It's like they had every attorney in Hardin County, didn't they? Because didn't y'all have 5 defendants or something?
We started off with 4, pulled it down, one testified against us. One, they dismissed outright, who testified in my client's favor. Mr. Price was in there with me as well. He was representing one co-defendant. So we whittled it down to 2 co-defendants, but it just
Kept going. Yeah. All right. All right. So when would you like me to reschedule Mr. Trulock for? All right. Just so Monday, give it a shot.
Yeah, Monday should be fine.
All right. All right, Mr. Trulock, we're going to move you over to Monday so your attorney can come see you. She was going to try to get down there last week. I can't tell how much of this you can hear, but she was going to try to get down there last week, and she had a trial that they didn't think was going to take all week. It ended up, she was in it all week. So she's going to try to get down there this week, and then we'll see you on Monday. Okay? In a few words. All right.
Charles Lester.
Bless you. Charles Busey Sr. Oh, Charles Busey Jr.
Senior.
Hold on, Senior.
All right, buddy.
Lord, what have y'all I've got? Hey, nabbit, here we go. I've got everybody, but I just need JR right here.
All right. Okay, all right.
How you doing?
I'm doing good. How you?
I ain't talking to you.
Oh.
I'm talking to Junior.
Oh.
You don't ever listen to me. All right.
We could shoot this over to, I don't want to keep that. Probably push it up to July. I'm just trying to understand. It's fine.
Yeah, I don't care. I mean, all right. Don't add those up. Those June 28th. I know, Mike will be the only one here. I mean,
Mike, do you have good life insurance?
all right, so 7/12. Yeah. No, June 28th. Mr. Busey, not the younger, her attorney will just make sure that she can get in touch with you. It sounds like she can. So if anything changes, let her know. Okay. All right. Thank you.
Don't say Regular gas.
Yep. Mr. Gas.
Discovery, also with some offer, but just like about the test for, when he was indicted for trafficking heroin. One of the bags was tested, came back as fentanyl. Now, it doesn't change the charge, it doesn't change the level of the offense, so I don't think, if we had amended it, but I think you have to amend the type of drug we're charging with. But now I've got to decide whether or not I want to have the second bag tested to see if that is heroin or if it's fentanyl. We could still try to negotiate the case, but I'm gonna need I'm gonna need probably a few weeks to talk to the lab and see how fast they can do that, if we have to do it, and if we have to do it at all, I don't know if they want to try to resolve it or not, based on our offer. Just to have some time to be able to do that. I would say though that it being fentanyl, kind of really dangerous enough, that fentanyl is definitely more dangerous. So I think it kind of raises some concerns there.
So are you thinking if you went, just so that I can understand what you're saying and he can understand what you're saying, are you thinking that if you tested the other bag and it came back a different substance, then you would like seek a superseding indictment or something like that to have two different?
For example, if it came back as heroin, one way or the other, I'd have to amend something different. I don't know if the second bag is fentanyl or heroin. All I know is that one of the bags, both bags are heroin.
I understand.
One of the bags that came back.
I understand.
Is actually fentanyl.
But I guess what I'm asking is, if you had two different substances, would you try to get two different charges of trafficking?
Yeah, so they may not have to. I just got the report Thursday or Friday, so I haven't really had a chance to.
Okay. Have you sent that to them, or are you going to send that to them?
If I haven't, I'll send it.
All right. Well, you want to go out a few weeks on this? I mean, we don't have to go to July or anything, or even June 28th. You want to go to the 14th? I know. Listen, I already know. Don't get mad at me. Or get mad and just stay mad. Don't get over it and then get mad again. All right, June 14th. Okay. We will see you then.
Judge Alexander, can I ask a couple things real quick?
Yes.
16 weeks ago, Judge Pendleton told me somebody from the DPA office would be up here to assess me to go to rehab. I've now lost 2 bed dates because I don't have a bond that I can make. I asked for a 10% bond to go to rehab. Evidently you denied that. I can't find anything out. My mother called the DPA office, and they don't know which DPA lawyer has me. Mr. Richardson is my prosecuting attorney, who's actually been my defense counsel before, which I think that's a conflict of interest also. He seems to think that I was the sole person in the house. There's 5 people that have that address as theirs. I have 2 females who were sharing a bedroom with me. One of those has trafficking heroin charges in 2 other counties. So I think I'm going to have some co-defendants when this all boils down. I think there's a lot of retaliation. The officer that come with the search warrant has, I've got video evidence of him calling me a homosexual and a queer. So I think it's towing prejudice towards me.
Mr. Gass.
Yes, sir.
Your attorney is asking me to ask you to quit talking, which is good advice. She's going to come talk to you this week, okay?
I don't even have a motion of discovery. I've been here 4 months.
Your attorney's going to come talk to you this week, okay?
So when are we supposed to be back in court?
What did I say? June the 14th? June the 14th.
So I won't know anything about going to rehab or anything till June the 14th.
I didn't say that. I said your attorney's going to come talk to you this week, and the next court date we have is June the 14th. I don't know what'll happen when she comes to talk to you. I mean, yeah, he's got a 10% bond. I'm not sure what he's talking about there. He's got, it's 5,000, 10%, I think.
Yes, Your Honor. Thank you.
Yeah. All right. Who's up next?
Judge, I had a couple that I don't see. We had Ian Jones. He was scheduled for trial in July.
Well, I see his attorney on here.
Did you say Van Jones, Your Honor?
Yes, sir.
Mr. Jones is on. He's on audio, that 270-576-4646 number.
All right. So he is the phone. Yeah. Yeah, Mr. Richardson. So I have Mr. Ward on here and Mr. Jones. He's appearing by telephone. Mr. Jones, can you take your mute off so that I can know that you, or so that you can acknowledge hearing me?
Mr. Jones, unmute your phone, please. Tap the lower left of your phone and hit the little microphone button or *6.
Well,
I just texted him to unmute too.
okay.
He's been on here for 3 hours.
Yeah, I've got two phones that, and neither one of them, you know, have a name or anything, so I don't know who they are, but I was assuming he was one of them. But I don't, which one, what's his number?
Judge, his phone is 270-576-4646.
Yeah, okay. Yeah, he's, okay, there he is. Can you hear me, Mr. Jones?
Yes, you had me muted, sir.
No, you do.
You there?
Yeah, I'm here.
Just say yes. You don't have to say
All
anything
right.
else, Mr. Jones.
I got you. All right. So, Mr. Richardson, what were you saying?
I was saying we're set for a trial in July. Mr. Ward and I had talked often about the case back and forth, but we never, we're far apart. You know, I'm always still open to negotiation, but I think I gave him the bottom line last time we had talked, and I still think we ever come close to that. I've talked to the victim in this case. She's actually in the military now, but after talking to her, she will be able to be here for the trials. I don't expect any issues. So as far as on our end, you know, unless we come to some sort of deal, I think we're going to have this trial in July.
Right now, I have us down for July 15th and if necessary, 16th. Is that what you have? And Mr. Ward, is that what you have?
Judge, that is what I have, but we have a very unique and strange situation here.
Okay.
I think I'm going to have one of the oddest COVID issues that we're going to have. One of the most important witnesses for this case, I'm running into some real difficulty subpoenaing, and that is the mother, Mr. Jones' ex-wife. She now lives in Australia and has for 2 years. As of May 14th, just last Friday, the New York Times is reporting that Australia's travel ban is going to extend into the middle of 2022. Australia has a complete and utter total travel ban. Americans are stuck there. Their citizens are stuck outside of Australia, and they are not relaxing that at this point. So we have trial in 2 months, and I have no way of serving or even physically getting this witness to the court.
Okay. Mr. Richardson, you want to talk about that?
I mean, my expectation was we were probably going to have her testify as well. Just not for most of the testimony. There are some parts I probably would have not testified to. So they, you know, it would be odd things, but you know, I don't think there's any Sixth Amendment confrontation concerns. If they're wanting to agree to have her testify over Zoom or something of that nature. Because I thought of this last week, Judge, with Australia, having their restrictions in place. So if they wanted to waive any Sixth Amendment concerns, I don't see what the issue would be to have her testify over Zoom. I'm not sure why they're wanting to subpoena her, but I think I probably need her for my case. So I think it falls in their court as far as that's concerned.
Have you thought about whether or not, we could arrange, for some sort of remote testimony on her part?
Judge,
Seems like both of you want her to testify.
Judge, that's true, but I don't think we're going to be in a position where I'd be willing to waive any Sixth Amendment concerns of a trial and charges of this magnitude. I've done some hearings over Zoom. I've done some suppression hearings over Zoom. They're inadequate at best. You cannot get a good, effective cross-examination. During those times, it's problematic to, we're going to have issues of internet quality with Australia, probably. My understanding is she lives in rural Australia. So, any chance of that happening, I think it's going to be problematic and prejudice my client. And it's not something that at this time we'd be willing to waive.
Well, that's fine, Judge. I'm not trying to push anybody to waive their rights. But I also think that while the defense isn't required to reveal their strategy, I don't think we can just simply say, well, we're going to subpoena this person. And heck, we can't find them, that we have to put the trial off. I think they would have to state, give an idea to the court. I don't even care if they even do it in private to you, Judge. I trust that you would be able to make a decision. This person truly would be a viable witness. I'm saying I'll probably meet her, but then during my preparation for trial, I may decide that I'm not. But I think at this moment I probably want to call her as a witness. But that might not be the case when we actually get to closer to the trial date. I think they have to do a reason this.
Yeah, this is what we're going to do. I agree with what you're saying that nobody has to, the defense doesn't necessarily have to tell everybody what they're doing or why they want to do it. But I do think that, what this really boils down to at the end of the day is a request for a continuance. And if we're going to do that, there's a formal way to do that. And I guess that's what we need to do. What I would prefer to do is move this pretrial to that Monday before the trial is supposed to start, with this understanding that you and Mr. Ward can talk to each other, see what, I'm not saying negotiate the case or anything like that, but talk to each other and see what's going on. If there isn't any way for the two of you to come to some sort of resolution of this problem, then you all get with me. We can do a Zoom hearing, just the three of us. And we don't have to wait for another court date. You can email me or get on a conference call with me. We can set up a thing. But I think if the issue is going to be that you don't feel comfortable proceeding and you're going to ask me to continue it, then I think we probably just need to go about that, the formal way and make a record of it so that moving forward, because I have an obligation to advance any cases that involve a child victim, alleged child victim, or child alleged victim, however you want to put it, on the docket. So, I don't want to just continue something without there being, the proof in the record that it needs to be moved. So that's how I would prefer to handle this. And I am not saying that I disagree with you, because but I do think that I need to get a formal motion, and then, we will need to probably have some kind of hearing, even if you and I, like Mr. Richardson said, even if we do some sort of in-camera presentation or something to find out what it is, because I don't want to get to the point where, not that I am blaming you for this or accusing you of this, but I don't want to get to the point where we have to put this off for another year and a half and then get there and say, oh, well, we decided not to subpoena that witness. And then, we've just hadn't done anything, for that long. So, which obviously you could still decide to do. I can't pin you down on it, but I would want to have, some good faith, some showing of good faith or something like that, just to put it on the record, if nothing else. Okay.
Judge, would you like to do it any sooner than the week before? Because I'll have some other motions to file before that as well.
Well, no, what I'm saying is I'm going to put it on that day just so that we have one other court date, but I'm expecting you all to talk between now and then. And, you all narrow down whatever issues you got to bring up and then get with me and we'll try to find a time to do the hearing. We'll do it. We'll just pick a day that's not on, if we can find one, that's not on a Monday, just some day where we're all available and we can get together and do it on a video. Okay.
So I'll send Mr. Richardson an email straight away.
There you go. All right. Thank you.
Judge, that's just to clarify that is going to be Monday, the 12th.
That is right. Yes, sir.
Thank you, Judge. Thank you, Mr. Richardson.
All right. Thanks.
That concludes our business. May we be excused?
Yes, sir.
Thank you.
Australia. I don't know anything about this Australia business. All right. All right. Bradley Miller. Oh, okay. She is. Bethany Stanziano. Can you hear me?
Yes, sir.
All right, there you are. Okay. I didn't know you had this case. I was.
Bradley Miller.
Yeah, this is Mr. Miller and
Yes, sir.
you're conflict attorney for him, right?
Yes, sir.
Okay. Have you gotten your discovery from the Commonwealth?
I have received it, Your Honor, and I have not been able to forward it to Mr. Miller yet.
Okay.
I'm not sure how long ago I got this case, but to be quite honest, Judge, my secretary up and quit without notice.
Uh-oh.
So it's been a little crazy around here, but I'm trying to get him a copy of his discovery by the end of the week.
Yeah, I understand. That kind of gets you in a bind.
Yes.
All right. So I need to give you all obviously time to get that to him and then, maybe build in some time for you all to talk. And
yes.
I don't know how easy that's going to be because you'll probably have to come. I don't know what options are available to you as far as talking remotely at the jail. I don't really know how easy that'll be. So, do you want to go out about a month?
We can. It doesn't necessarily have to be that long either, Judge. I know most of the jails, I can call and email them a link for a Zoom meeting, and it's usually not an issue. So I can contact the Barron County Jail later on today and find out if that's a possibility.
Yeah, I'm sure they'll try to accommodate you as much as they can. Of course, they're doing a lot of Zoom hearings for various courts and stuff. We hold inmates for several counties, and we have a lot of state inmates down there and that kind of thing. So, I'm sure they'll try to accommodate you.
Okay.
We'll see if it works. All right.
All right.
Well, 2 weeks is Memorial Day. 3 weeks is June 7th. 4 weeks is June 14th. So it can be either one of those days if you want to.
Let's do June 7th, Judge.
All right. Yeah. I don't remember what we said. Oh, yeah. Well, that's too quick. Yeah. All right. June 7th is fine.
Will that be at 1, Your Honor?
Yes, ma'am.
Okay.
All right.
Thank you, sir.
Thank you much.
And Mr. Miller, I'll be arranging for us to talk this week.
All right, that works.
All right. Thank you.
That's fine. Yes, ma'am.
All righty.
Alexander, can I ask you a question, man? Please.
Yes.
All right. Well, first off, I do want to apologize for my outburst on the arraignment last week or the week before, whichever one. Second off, all right, Louisville Metro they got me on a ROR for my case up there. And whenever me and you last talked, you said you would take my bond under advisement because I got my 7-month-old son out there that I am the primary caregiver of, and my mom's going through cancer right now. So if possible, or I'm saying you'd find it, I'm saying okay if you could unsecure my bond to where I could sign myself out to be there to take care of my mother and my son. I mean, I don't know what kind of situations are going on right now, but I definitely need to be out there to care for them. I don't have no priors of missing court or anything, man. So if possible, man, please. Because there's no way I can pay no cash bond or anything. I don't have nobody out there to do it.
May I ask if you have anybody to sign?
No, I live in Louisville. My mother, she actually lives over in New Albany, Indiana. I mean, that's why I was saying I literally have nobody to do anything for me. Like I'm kind of in this on my own. So if possible, I'd like to sign myself out. But like I said, I don't have no priors of missing court or anything.
Judge, I was gonna say, he's got a conviction for escape out of Jefferson County. He's got multiple felonies.
I have been in custody now for 105 days. So
Got the bonds that would be able to make sure that he's not out to commit any more crime. I also want to note this case, Judge, well, it's 2 cases really. He was out stealing from multiple places, and they actually found a list of places that were hit up even outside the county. They found amongst the evidence. So this is ongoing pattern of criminal conduct. I don't believe there's any justification at this point, based on what he said already, to be able to.
Judge.
Well, I mean, his risk assessment for risk to reoffend was a 9, which, you know, you've been doing this long enough, Ms. Stanziano, to know that, I mean, you know, we can have people with pending charges in 3 or 4 counties and they're low risk to reoffend. He had charges, you know, theft type charges just all over the place. And he does have a prior conviction for escape, which is the reason that his FTA risk is higher than a 1. I mean, you know, it's a 3, which
Sure.
is, again, not the highest one I've ever seen, but it's not ideal.
Sure.
You know, so I, you know, there's a lot of things at stake here, but there was a lot of charges getting picked up here in a short period of time. You know, we've got, 5 separate theft or receiving stolen property charges. You know, there's a record or a history of multiple similar charges in Jefferson County. You know,
Would the court possibly consider maybe 10%ing its last order of $2,500?
I mean, I don't know that I would be all that opposed to that. I guess what I would want to know is what your plans are as far as seeing him, because I don't want to make it to where you make some kind of efforts and then they end up being, you know, all for naught because he's not there.
Right. I will make arrangements to talk to him no later than tomorrow, if the jail can do that. And then, which will also give me the chance to see if I could contact his family or a family member and see if they could, you know, come up with 250 instead of 2,500 or 5,000. And Judge, I think that maybe even, you know, an order that he remain out of Barron County except for court appearances.
Well, you know, I'm not that, I mean, it's not that I don't want him stealing from people in Barron County. I don't want him stealing from people in any county.
I understand, Your Honor.
I mean, I'm trying not to be a homer.
Your Honor, I understand where you're coming from, but I do know that you are known to give people one chance. I haven't even been given any chance at all, and I have been in custody for 105 days today. So, I mean, I'm just asking for that one chance. That's it.
Well,
if I mess up, then saying I'll let the, you know what I'm saying, the cards be in your hands.
I will give it some consideration. Right now, we're going to put it on for June the 7th. I will you know, I'll see if I can come down any more than what I had already done. Okay.
Thank you, Judge.
I'll just have to think about it. All right.
Good to see you.
Same here. See you later.
Thank you.
Bye-bye.
That's what I thought. I was getting ready to just jump on you. Oh, yeah. Who you want? Thomas Dobson. There he is. Yes, sir, or ma'am.
You have agreed with this case, correct? Emailed to you.
Not unless it was sometime today. Well,
Yeah, I have forwarded on. I will send it to Chrissy if he's called up the case.
you have it?
Yeah.
Okay.
I just, need John's signature on, and I had emailed them to him.
Okay. Mr. Gardner, we've got the originals right here, I think.
Yeah.
Oh, yes, ma'am. That's fine. Okay, thank you. Thank you. All right, Mr. Dobson.
Yes, sir.
Can you hear me?
Yes, sir.
All right. Will you raise your right hand for me? Do you swear to tell me the truth, so help you God?
Yes, sir.
All right, thank you. Let me just make sure I've got so are there 3 cases or?
There are 3 cases, Commonwealth has agreed to dismiss the Ford Century case and supply a motion.
Okay, all right. So I'm only going to need 2 motions. All right. Mr. Dobson, let me, I like to get up here where I can see you, okay? All right, here we go. So I have 2 motions here to enter a guilty plea, 19 CR 331, 20 CR 279. This is the first one. Do you see that?
Yes, sir.
And that's your signature. Do you see that?
Yes, sir.
Or that, I guess that should be your signature. Is it in fact your signature?
Yes, sir, it is.
Okay. This is your plea offer in that case. It's got your name, as you can see, your court date or your court case number. And then there's a signature page there. Is that your signature?
Yes, sir, it is.
All right. I'm going to move on real quick just to talk about the second case as well, so we can talk about your paperwork there. There's your motion to enter a guilty plea. And there's the signature page. Does that appear to be your signature?
Yes, sir, it is.
This is your offer in that case with your case number, your name. Move on down here to the signature page.
Yes,
Is
sir.
that your signature? All right, very good. Thank you. So did you read all of these documents before you signed them?
Yes, sir.
All right. Did you discuss them or at least have the opportunity to discuss them with your attorney if you needed to get any questions answered that you might have needed?
Yes, sir, I did.
All right, all right. Are you satisfied with the amount of time that you have had to talk to your attorney?
Yes, sir.
Mr. Dobson, do you feel like you are under the influence of anything today?
No, sir.
Are you having any difficulty exercising your judgment today?
No, sir.
Are you having any difficulty understanding me?
No, sir.
Do you believe that anyone is making you plead guilty?
No, sir.
Do you understand that you have the right not to incriminate yourself? Sometimes we call that the right to remain silent, and you waive that if you plead guilty.
Yes, sir.
Do you understand that you have the right to a jury trial where the Commonwealth has to prove guilt beyond a reasonable doubt? You could confront and cross-examine the people that give evidence against you, and you could put evidence on in your own defense, but you waive each of those rights if you plead guilty.
Yes, sir.
Do you understand that you waive the right to appeal if you plead guilty?
Yes, sir.
All right. In 19 CR 331, the charges in that case are wanton endangerment in the first degree, which is a Class D felony, and possession of drug paraphernalia, which is a Class A misdemeanor. The Commonwealth agrees on a plea of guilty to recommend 3 years on the wanton endangerment and 12 months on the paraphernalia to run concurrently for a total of 3 years. The Commonwealth would agree to probate that sentence for a period of 3 years after serving an alternative sentence. And the Commonwealth would agree that your time in custody prior to entry of this plea would constitute your alternative sentence. So in other words, you would get a time served alternative sentence. You understand that?
Yes, sir.
Your probation would be conditioned on getting an assessment with probation and parole for any kind of substance abuse issues. And then you would have to complete any recommended treatment. They may not recommend any, but if they did, that would be part of your probation. Do you understand that?
Yes, sir.
All right. Other than that, has anyone offered you anything or promised you anything in that wanton endangerment case to try to get you to plead guilty?
No, sir. They haven't.
Are you pleading guilty voluntarily?
Yes, sir.
Do you feel like I am making you plead guilty?
No, sir.
Do you feel like anyone else is pressuring you or otherwise trying to force you to plead guilty?
No, sir.
Are you acknowledging, Mr. Dobson, that on May 22nd, 2019 in Barron County, Kentucky, you committed the offense of wanton endangerment in the first degree when under circumstances manifesting extreme indifference to the value of human life, you engaged in conduct, you wantonly engaged in conduct, creating a substantial danger of death or serious physical injury to a minor?
Yes, sir.
Are you also acknowledging that at that same time and place, you used or possessed with the intent to use drug paraphernalia?
Yes, sir.
All right. Then I can accept your guilty plea in that case, and I'm going to move on to your next one. This is 20 CR 279. I've already asked or gone through your rights and everything with you and so forth, and you stated that you understand those. The Commonwealth is offering the following: possession of a controlled substance, first degree, first offense. That is a Class D felony. The Commonwealth would recommend a 1-year sentence. Count 2, drug paraphernalia, Class A misdemeanor. The Commonwealth recommends a 12-month sentence, those to run concurrently for a total of 1 year. The Commonwealth would agree to probate that 1 year for a period of 3 years on the condition, again, that you get that substance abuse assessment through probation and parole. You would be supervised by probation and parole. And this sentence would be consecutive to the sentence that we just discussed in 19 CR 331. Is that what you understand your agreement to be?
Yes, sir, yes.
All right. Have you been promised anything other than what I just talked to you about to get you to plead guilty?
No, sir.
Again, do you feel like I'm making you plead guilty?
No, sir.
All right. Mr. Dobson, are you acknowledging to me that on February 29th, 2020, in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes, sir.
All right. I am going to accept your guilty plea in those two cases. It is also my understanding that the Commonwealth is going to move to dismiss your third case, which is 19 CR 395. So they'll file a motion and give me an order and I'll sign that and I'll take care of that case. Okay.
Yes, sir. Thank you.
Now, do you want to go ahead and get sentenced today or do you want to come back on a later day for your sentencing?
Go ahead and do it today.
All right. Because you're in custody, that's a pre-sentence investigation is waivable. All right. So I'll accept your plea in each case and we'll do, go ahead and sentence you in a 19 CR 331. It's a 3-year sentence, alternative sentence consisting of time served, balance suspended for 3 years on the condition that, are you following along with me in case I get something wrong? I gave her your pleas, so I'm just trying to remember what you did. Balance suspended for 3 years on the condition that you comply with probation and parole and you get a substance abuse assessment. If they recommend any treatment, that'll be part of your probation. In 20 CR 279, I'll sentence you to 1 year consecutive to the prior case, grant your motion for probation under the same terms and conditions as in the previous case. Do you understand all that?
Yes, sir.
All right, I'm waiving your fines and your court costs due to indigency, okay?
Yes, sir.
All right, your probation, you'll need to report to probation and parole by 9 tomorrow. All right, you know where the probation office is?
Yes, I do.
All right, so you're gonna be getting out today. Okay? And
Thank you, sir.
you need to report to the probation office by 9 o'clock in the morning.
All righty.
All right. And they're going to talk to you when you get there and they'll ask you to fill out some things. And then, you'll get up and running and they will tell you when you're supposed to report and all that stuff and just do what they tell you to do. Okay.
Yes, sir.
Do you have any questions?
No, sir.
All right. Good luck to you, sir. Okay. Take care.
Thank you, sir.
Glenn Booth.
Glenn Booth.
Judge, waiting on the court case. Can't remember when the court last on the thing. But I just signed the discovery this morning. Greg had an opportunity to look at that and talk to his client about it. I did talk to my client, not about the discovery.
We were reset so quick to see what kind of a real, how much fun we might be talking about. So we were interested in trying to get them a bond. Or talk about setting a bond and the amount, or something like that. Right. I'm thinking right now.
His bond was 5,000 surety. The amount that was in the indictment was 7,700. That's probably what you were thinking of. Okay. Yeah, that number went way back to 2016.
You know, he's from Georgia. Up here, he's got pretty serious health problems. Back surgery, 2 back surgeries, 1 accident. So he has a lot, a really rough time being in jail. If there's any way we can, sometimes sign himself out or something, to allow him to go back to Georgia and he'll have to, of course, come back up here to deal with this case.
Well, I guess that's kind of where the rub comes in because, if he makes, so, I mean, basically you're telling me he ain't gonna be able to make a surety bond. He doesn't have anybody that could sign it. Yeah, I mean, I guess, again, where the rub comes in is if he makes a bond, it's gonna be conditioned on him paying child support as previously ordered. And if that doesn't happen, I mean, we're gonna end up right back where we started.
Got a guy named Mark here. I believe he's working on it. Might be willing to help him on the line. Well, it's signed, he got rid of it.
Okay.
I don't know.
Well, it wouldn't be necessarily all that helpful, I don't guess. I don't really know.
I have somebody, a friend of mine, Mark Garrett's gonna help me pay until I get my check started now. I mean, I'm not gonna miss no more at all. I've done.
Are you trying to get disability or something? Is that the deal?
Yes, sir. I'm disabled and I'm real close to getting it. And my friend, he's gonna turn around. He's the same one that said, you know, we talked a couple weeks ago, you said you would give me a bond. And I told him, and you said something about bonding on 10%. And I told him that, and he said, okay, let him know. And then he also told me to tell you he'll send a check every month to child support until I get my check started, because I have no income right now.
What's your child support monthly supposed to be?
See, I can't remember. I was thinking it was 2 something, but I'm saying around 300.
All right.
I mean, don't hold me to that.
No, I'm just trying to figure it. So, but you're not saying this guy's going to pay some money to help you get out of jail. You're saying if you get out of jail, he's going to try to pay you some money to help you stay out of jail.
Well, that, and he said he would come up and bond me out.
He just needs an amount.
Yes, because you told me you'd set me a bond and let me bond down 10%, but all of it would go to child support, you know?
Yeah.
And I told him that, and he said, okay. So he's actually talking about, you know, you set me a bond, and then on whatever 10% is, he said he'll come up and bond me out, and then, you know, he'll write a check or send it however he was going to do it.
All right. So they're telling me that your bond or that your child support arrearage right now is over $20,000.
Mm-hmm.
So 10% of that would be somewhere in the neighborhood of $2,000.
Yes, sir.
Is he going to have that?
He can come up. Yes, sir. He will pay that. I talked to him this morning.
Well, he's you better not make him mad.
No, he's real Christian too. He wants me to get back in church and everything. They're real nice people. And yeah, I told him, I said, you know, yeah, this is it for me. I got to get this taken care of. I got, you know, everything.
Well, yeah, I mean, you got to get on that child support because, you know, somewhere, and I don't know if it's here or where it is, but somewhere there's somebody that's supposed to be getting it and they aren't getting it.
Yeah, exactly. I understand. I do. I understand.
Okay. Well, I mean, just I guess for the sake of a round number, I don't know. I guess what I could do is set his bond at 10% of 20,000 and let this guy come up and post it, and then make a condition of it that, you know, starting in the first month afterwards, he starts making his child support and makes them current, and make the bond conditioned on that it's posted, because it's going to be forfeited into child support. I mean, that would be he would need to know that coming in, you know, where you're going to owe him the 20,000 because it's going to get took.
Yeah, he knows.
All right.
Yes, sir. He just mainly to help me out, get me out and all. That's all. The rest of it's, you know, it's on me, but he's just trying to help me out so I can get my check started because I'm real close because this COVID stuff slowed everything down. And
understood what the judge is saying. I mean, if he signs that bond for you, you don't pay the child support like you're supposed to, we're gonna come after him for the $20,000.
Oh, yes, sir. Yes, sir. He knows. Me and him talked about that too.
I mean, you're going to be he gonna have his hooks in you because you're gonna, like I said, you don't need to make this guy mad.
That's it. I know. Yeah. I know.
All right.
sir. Yes,
All right. Well, so Amy, are you on here? I know you're on here. Can you hear me?
Yes, Your Honor, I can.
This is what I'll do. I'll modify Mr. Booth from 5,000 approved surety to 20 at 20,000 at 10%.
Okay.
You know, which to be put up in Mr. Booth's name for application to arrearage. And bond conditioned on make all court appearances, stay in contact with counsel, and make current child support payments.
Yes, sir.
So, I mean, even if you don't have your disability started, that doesn't relieve you of the obligation to make your child support payments, right?
Yes, sir. He's actually going to help me make them every month until I get my
I
disability.
understand. I just want to make sure that there aren't any surprises for anybody lurking around the bend. You know what I mean?
No, sir. No, sir. I know what you're saying. Yes, sir.
And another condition of your bond is going to be if you do succeed in getting your disability, you can't, and you get back pay, you can't spend that back pay until you get permission.
Okay.
Because, you know, that'll help you. If that happens and you get it before this case gets real old and it gets resolved, then that'll go a long way towards helping you get this case resolved, you know, having some lump sum money to pay on your arrears.
Yes, sir.
So don't, you know, run off to the riverboat with it. Don't spend it until we talk again.
Yes, sir. And I was also wanting to ask you, now, you know, there was two different warrants. One was the bench warrant, which I guess you said something about that. And the other one was the other warrant. I know you talked about it. It had the 5,000 on it. Now, the other one, it said something about, it's where I failed to pay, you know, start with, keep my, whatever it is.
That's what I was going to say. I knew there was something I was forgetting, and now I remember. I think he's serving a pay or stay out of family court.
Well, the thing about this is I should have already done it. I spent 39 days down there and then come up here, and I've been here for 2.5 weeks.
Amy, is that anything you can look into?
I'm showing Judge, well, the only other holder we've got is a 13J 180.
That'd be it. That'll be it.
But I can't pull it up. The J case.
Oh, on account of it being a J and all.
Yeah. So all I have is case number. Sorry.
I think he's got a pay or stay.
It is. It is. It says, I don't have it on me, but I do have it. It's
Hold on.
Failure to pay is ordered defendant to serve 34 days, may purge by paying $4,620.
36 days.
34 or 46.
Does it show when his warrant was served on him?
429.
4/29.
Yes, that's what we've got.
Because that warrant probably didn't get served on him in Georgia. It was probably this one that got served on him in Georgia. Yeah. Amy?
Yes, sir.
Is that something that's within your bailiwick that you can talk to a family court, or do I need to do that?
Doesn't matter, Your Honor. I can do it.
Matters to me.
I'll take care of it.
It helped me a lot if you're the one that did it.
I'll do it.
What day did you get arrested in Georgia?
I got arrested on 21st of
March?
yes, sir, March.
Because 21st of April wouldn't even be a month ago yet. So
No.
that wouldn't.
The only
Yeah.
reason I said April, because see, my son down there's birthday was on April 24th, and I was already locked up for a whole month.
All right. So, Amy, I guess what I'm trying to do is see if we can get, since he's been in custody that long, see if the family court judge is willing to call that a credit. And, you can explain to her what I'm doing and that we're getting a big hunk of that right now. And that, this 2,000, if he posts it, would be about half of that pay or stay amount anyway. If she
Yes,
was-
sir. Okay.
She was willing to.
I'll check with her.
Of it.
And is there any way, I was wanting to try to find out, he could actually be up here tomorrow to do that. He already told me.
Yeah, I think probably what you need to do is wait until my pretrial officer talks to the family court and see if that's going to work, and then she can get word to you.
Okay. Do you know about how long that might take? Or-
And then holler at that guy. Oh, I mean, I'm sure she'll talk to her as soon as possible.
Okay, and they would, how would I mean, they'll let me know here?
Yeah, y'all can get word to him there, can't you, somehow, Amy?
Yes. I'll make Bonnie knows.
All right, fair enough. I mean, yeah, there's just a lot of moving parts here. We'll have to try to get it all synchronized, okay?
Yes, sir. Do you know about how long so I can let him know?
No, I don't. I mean, you'll just need to wait until you get word, and then you can, then you can get with him.
Okay.
I mean, there'll be a day or two where you just have to wait on him.
Yes, sir.
All right?
All right.
All right. So I guess I need to give y'all a court date, don't I?
Yeah.
And what I'd like to do, why don't we put it out into maybe late July so that we've got time for all this stuff to mature. You want to do July 19th? Mr. Booth, can you give us a phone number, or do you have a phone number, Greg? Can you give us a phone number where your lawyer can get you?
Yes, sir. It's 706-844-2539.
844-2539.
Yes, sir.
Area code 706.
Yes, sir. And if you want a backup number, I can give you the Mark's number, one that's going to be bonding me out and everything.
Yeah, he's going to be sticking pretty close to old Mark. We'll get his number too. What is that?
678-758-1663.
All right. He may already have that number.
Yeah, he does.
All right. Fair enough. Do you want to give him a number, or I guess Bonnie can give you, Bonnie, can you give him Greg's number?
I will, Judge.
You know it?
I do.
All right, super. All right, Mr. Booth, let's make this work.
We will.
All right. We'll be seeing you.
All right, thank you.
July 19th at 1:00. All right. Yes. Well, his senior picture's on here.
Gonna call Trey Williams in. I don't know if Trey Williams.
Ken, can you hear me?
I can, Judge.
Trey Williams?
He's on the line, Judge.
All right.
Trey, are you there?
Yeah, I'm here.
Okay, good. Judge, he's present.
Yeah, I see him.
This is Reese's case. I think at this point, she was talking about setting it for trial. It's already been set for trial. And they continue. We could been any settlement talks or got close to settlement. We want to set another pretrial in July. We would set the trial date, but we would set it now.
Okay.
It doesn't,
I don't show that we ever had a trial date in this case.
that might be the case.
He might have had a trial. Is it possible he had a trial date in Monroe
Monroe.
County?
Yes,
That
Judge, it is.
Got moved?
That's correct.
Yeah. So when's that gonna, I mean, what, give me the
Judge,
lay of the land on that.
You had discussed earlier about Tanisha Shirley, about her having a case in Monroe County, and the problem there, of course, they're not having in-person court right now, and I don't know when Judge Williams is going to be setting the trials for those cases down there.
Okay.
But we have gotten a very reasonable offer. In this case, Judge, our dilemma was taking that offer before the case is resolved in Monroe County because, of course, the possibility of getting his bond revoked.
Well, I won't tell him if you don't.
Well, I won't tell them, but I'm sure they might have a way of figuring it out once probation and parole happen to see that.
Huh. Yeah. Here's what I'm doing, Ken. I'm going to put it on for another pretrial on July 12th at 1 o'clock. That gives you time to figure out what they're going to do in Monroe. If we don't have anything worked out in this case, then I guess we can set it for trial then, okay?
Judge, are you setting those for next summer?
What, trials?
Yeah.
Hell, whenever we get them.
If you want to set this for summer of 2022, we're okay with that.
I'm going to set it for July 12th, and we're going to come back on the pretrial, and then you all are going to tell me what we need to do.
Okay, we can do that, Judge.
All right.
Thank you.
Yep. Now we got Mr. Johnson on here. Greg, I can bring him up and tell him what we had talked about. Mr. Johnson, your attorney's office has secured you a bed date, if I understand correctly. But you've got another case that's floating around pending before the grand jury, and I think what they're going to try to do is get a plea offer on that and do what we call a direct information, and we're going to put that on for Wednesday morning so that we can do that on Wednesday morning, and then we'll get you to your rehab spot.
All right.
So we'll see you Wednesday morning, 9 o'clock.
All right. Thank you.
Oh, you know what? Bonnie?
Yeah, Judge.
What do you got to do with, when do you do district court, Metcalf District on Wednesday mornings?
At 8:30.
8:30? Will you be done by 9, or will you think it'll be, more like 9:30?
I want to say probably 9:30. Depends on how many people I've got.
All right. Well, we better call that 9:30, but of course you'll be over here anyway, Greg, because we're doing that other deal, and we'll call it 9:30, Bonnie.
Okay, Judge.
And just do our best. All right. I need to set that up. Don't let me forget. I need to set a Zoomer up for that.
Ruby Waters. Didn't show where I sent. Ooh. Discovery should have been sent out. I'll double check on that. Make sure it's got it. saying. So you might do it in my house. Not that much side.
All right. What do y'all have? I'm sorry.
Another pre-trial conference in this, in July or in August. Would be bad.
Does that work for you still?
I'll be back.
July? All right, thank you.
Chastity Stewart. This is a possession case, Your Honor. I gave her an offer today, so, I think we resolved it probably. We'll see.
Yeah, I mean, I guess I kind of hate to go all the way out to the end of July if you think it's going to work out. It'd be the 7th or the 14th. It'd have to be one of those two. Yeah, that's fine. Can you tell me your address? Because the last letter we sent, it said that the address we had for you was insufficient address. I don't know why.
It is 2543 Old Monthville Road.
That's what we had.
Is it Glasgow or Cave City? Glasgow.
Well, that's why, because we had KC.
It does that. So far out there, it messes up.
Got a lot of explaining to do. All right, June 7th at 1. Thank you.
Virginia Rodriguez, she's on the dock.
She's on the Zoom here.
She's out with us, correct?
Yes.
I think there was that issue with that.
It looks like she put up this morning.
I think she,
Jill, or the jail sign was showing she was let out this morning.
yeah, I guess she had that district court deal that, because my order was done way back on May 3rd. Actually, April 26th. The order that we did was way back on April 26th.
Yeah, and I think district court amended her to unsecured on May 11th. It may have just taken a little while to catch up with the jail.
Oh.
She didn't get out to this morning. I don't think it was.
Okay.
On this case, so they would pass it to see what time we do as far as the revocation. I think that we would have a fairly good equitable tolling argument because obviously we called COVID and filed a motion and then proceeded like we normally should. Obviously, circumstances intervene, but we're not going to do that. She has a new felony case. It's still in the district court, only been indicted yet, so we'll just move forward on that.
Okay. So, yeah, this case would just be, we're just going to consider that she's off probation in this case, and that's all there is to it. And then we'll deal with the new case when it comes up. Right? That's the way to put it. All right, Ms. Rodriguez, can you hear, hear any of that?
No, I didn't. I'm sorry.
Feel like I'm watching somebody,
I'm fighting with my dog. I'm sorry about that. I was fighting with my little chihuahua.
Oh.
Yeah.
Yeah, better you than me.
Yeah, I'm on house arrest right now.
Out of district court?
Yes.
All right, well, that'll, I guess, just stay that way and unless or until you find out anything different.
I was going to be like that until I go to the grand jury.
Okay, well, you were on probation in this case that we're talking about, but your probation has ended. So, that's basically what you needed to be on here today for, was just for us to tell you that you're no longer on probation in this 2017 CR 305 case.
Okay.
All right.
All right.
So your only pending case that I'm aware of is the one that you're wearing that monitor for.
Okay. Do you know when I'll go to the grand jury?
I don't know.
Okay.
Okay.
Okay. Okay.
All right. See you.
All right. See you.
Issue, and Greg had me get in touch with his dad.
Yeah.
I offered Greg deferred prosecution forward. At this point, I'm just going to file a motion to dismiss without prejudice. If I need to bring back up something.
Yeah, I think probably even trying to Zoom with him would have been almost impossible because he had some hearing issues and yeah. All right. So on motion of the Commonwealth, dismiss without prejudice. All right, we can handle that. I mean, we don't have to do anything else unless you just want to tender an order. I wrote it, so. I mean, not unless you just want to, for the record. Yeah. Well, yeah. All right.
Tyrus Mitchell.
Yes, sir.
I talked to Greg about the resolution. I think we talked to him. The counter offers, and I countered that. Tyrus.
All right, Mr. Berry, we can do it. All right, so we're going to go to next Monday.
Your Honor, is there any way I could be possibly out on bond till then? My nephew's graduation this weekend. That's what I was wondering about. That's why I was really wanting to push forward if I could with the case today or make bond either way. Either way possible, so I can make sure I make it to my nephew's graduation.
I'm not sure I can see my way clear to do that. I mean, I don't want you to miss the graduation, but I mean, we had your bond revocation hearing and that is what it is.
I understand. That was 2 months ago, Your Honor. I've been sitting here since then. I mean, I can do any conditions or whatever I need to do for that PM period, or if there's any way to push forward to the day to handle this case where I can be there to make sure I'm there for it.
Well, it probably feels like 2 months, but it was just a month.
No, it's 2 months, Your Honor. I came in on March 15th.
Yeah, but your hearing was just a month.
Oh, yeah, for my hearing day. I was talking about in time period, sir.
I don't know what you all have in the works, if anything. I don't know.
I would assume if he does agree to this, or the offer is an alternative sentence. I think I'm satisfied with the alternative sentence.
Okay.
There's no way to do a furlough, Your Honor?
Mr. Mitchell, I don't think that's going to work. I mean, I understand, listen, I mean, I understand why you're asking, and I just don't think I can do a furlough under these circumstances. You got, we're going, maybe we can get it resolved next Monday. Mr. Barry's going to come talk to you. There's been some negotiating back and forth between the attorneys, and that, that's where we are. Okay?
Yeah, all right, thank you.
All right, yes, sir. Ms. Choate is on here. It is, apparently she does have she did have a letter that she could get in someplace, unfortunately, until 5/17 at 5:00 PM, and it's 5:35. So, but I didn't know about this letter till just now. I mean, I knew there was a letter, but I didn't know what it said. But I bet you they could, I think, Bethany got it, didn't she?
Already have it moved.
All right, so she still got it available? All right.
Yes, sir.
My understanding was that the deal on the table, or the offer on the table, was for her to do this, to go to residential treatment and then follow that up with drug court, and then she would be doing drug court in Warren County and they agreed to take her, but only if she did this treatment first. So is that, I mean, are we pulling the trigger on that or no? Yeah. Yeah. Well, and it's in lieu of, I mean, it's in lieu of revocation. So, I mean, I think she's certainly got some incentive to want to take this. It's not a guilty plea type of deal. All right. Miss Choate, are you going to be able to get yourself there?
Yes, sir. My mom can take me.
Do you know where you're going?
Hope Haven and Franklin.
Yeah, but I mean, do you know how to get there?
I mean, I have GPS.
Do you have the address? What, are you just going to type it write it on a piece of paper and hold it up in the air and hope you find it?
No. I haven't been gave the address yet, no. But I've got the lady's phone number that I've been in contact with at Hope Haven. I can get that.
All right. Do you understand that the condition of this is that you will enter and complete that? You have to have a negative COVID-19 test, which you probably haven't been able to get there in jail. So you'll have to go do that tomorrow before you go.
Okay.
You have to enter and complete this program. And then you will have to, I guess we'll send something to drug court so that they know she's there, and then they'll make contact with you over there and tell you about how to report and where and when and so forth when you get out.
Okay.
If there's any aftercare, you follow the directions on that too, okay?
Yes, sir.
Do you have any questions?
Will I be able to get out today to go home and get my clothes and stuff together?
Yeah. Well, Bethany, she just needs to be there tomorrow by what time?
Typically, it's like 9.
I think the clinic opens at maybe 7:30 there that does the rapid tests. So
yeah. So I'm going to tell her, all right, I'm just going to say that, okay. Previously her intake was 10 a.m. So let's say 10 a.m. and we'll let them know that.
Okay.
So 5:18, 10 a.m.
Okay. And I will be getting out today?
Yeah, we're going to send something down there to the jail directly. You'll get it.
All right. Thank you, sir.
But you won't get it. Bonnie will get it.
Okay. Thank you.
All right. Thank you. Anybody else, Bonnie? Oh, we still got Mr. Busey.
Yeah.
All right. Ooh, let me put that in there. Sorry. What are we thinking with Mr. Busey? How long? Oh, it's okay.
I think if we set them over for June 7th, that would give me an opportunity.
I've got the traffic.
Oh, you've got the traffic?
Yeah.
Oh, okay, sorry.
All right, Mr. Busey, they're asking just to get this rescheduled one more time to June 7th so that everybody can dot their i's and cross their t's.
Yes, sir.
So that's what we shall do. And then I'll see you then.
Okay, is there any way I can make mine, get my witnesses together?
Well, let me let your lawyer come talk with you first before we start worrying about that, okay?
Yeah, okay, I didn't know, you had a hold on me, I didn't know what to do. I'll be willing to do, go take drug tests, is what you want me to do. I've been staying in pain like I'm supposed to be doing. They arrested me over some charges, and I mean, I know they arrested me over some charges. It's felony. Wouldn't mind. I've been doing like I'm supposed to be doing.
Let's just kind of see how this works out here with your attorney's got a couple things she needs to check on, then she's going to come talk to you. We'll come back in a couple weeks and then we'll go from there. Okay.
All right. But I make buying, will you let me know about buying then?
Yeah, we can talk about it then.
All right. Thanks. Thanks, sir.
All right. I don't see anybody else.
I did.
Hold on, Alexander.